Good morning all. It's 29 minutes past 9 on this chilly Monday morning. We are ready to start the day's proceedings. Please make sure that your cell phones are off, your devices are on silent so that they don't disturb the proceedings. Thank you.
Good morning, Mr. Shaskolsin. Good morning, Ms. Sigels-Ncube. Good morning, Mr. Ramatsekisa.
Good morning.
Good morning, Mr. Adams.
Good morning, Justice.
Morning, Chair. Chair, we had hoped to be questioning Mr. Adams today, but unfortunately, we're going to ask for his questioning to stand down until the 19th. The background to our request is that although we have been requesting a statement from Mr. Adams since the 25th of October last year, it finally arrived after 9 o'clock last night. And I think it's important for the public to understand how the Commission operates, because there's this sort of sense that we all sort of just arrive and we can just start questioning and operating instantly because we can integrate all of the information. We know what we want to ask, we know what we don't want to ask, we know how we're going to ask it. It doesn't work that way. You, Chair, and your co-commissioners have to read a statement, have to prepare before a witness is called, so you understand what the witness is going to say, you understand what issues you have. We have to plan our line of questioning in the line of what the witness says. It's simply not possible to do that when the statement arrives essentially 12 hours before the witness starts testifying. And Mr. Adams is an important witness, and we would not be doing justice to this process if we just kicked off and blundered on the basis of a statement that we received last night after 9 o'clock. So we've spoken with Mr. Adams and his legal team. Mr. Adams is available on the 19th. We now have a statement from Mr. Adams, and we would ask that the matter stand down to the 19th of August.
Also, Mr. Adams is legally represented, you say?
Sorry. Not Mr. Adams' legal representatives. I'm sorry. We've spoken to Mr. Adams himself.
All right. And you said the statement was sought from him when?
Well, the first Rule 3 went out to him on the 3rd of August. And then there was, 3rd of October last year. And then a response was sought by 25 October last year. There is a long and lengthy correspondence running through from October last year, and then it starts to accelerate through April, May, June, July.
Which was about what?
Which was about getting the statement and getting a response to the Rule 3. Where that correspondence finally ended was that we our last offer was an agreement that the statement could be filed by Thursday last week, which we thought was, we could accommodate Thursday because we could then print on Friday, give the commissioners copies to read over the weekend. And eventually the affidavit came in late last night. I can take the Commission through the correspondence. I'm not sure what would be gained by that.
I don't think it's necessary unless Mr. Adams suggests something contrary to what you have said. No, it's not necessary. Perhaps let us hear from Mr. Adams. Is it correct, Mr. Adams, that you received a rule pre-notice which required of you to file a statement in October of 2025?
Good morning, Commissioners. Parliament can confirm that I have a very problematic laptop. And my laptop is either in for repairs or frozen. And when I became aware of the emails, it was, I really don't want to lie. I think around about March.
You would not have to lie, so you don't even need to.
No, Commissioner, at any rate, I was aware of the Roof 3 a few months ago. But
what's a few months ago?
I think 3 months ago, 4 months ago, when I became aware of it. I had not noticed it in October.
Surely this is something very important. You cannot be as unspecific as you are. When did you first become aware of the Rule 3 notice?
If you're going to ask me for a date right here, Justice, I really wouldn't be able to give you one, but it was a few months ago. But I'm under the impression that I will be getting more questions because people are mentioning me every day, so I was waiting for that. And Honourable Jackelson is 100% right in his assessment. But eventually, I saw that I wasn't going to get a subpoena, and that is why I emailed the Commission.
Is the laptop you are talking about the same laptop you are using for your parliamentary business?
It is.
So are you telling us that you are able to function in Parliament with a laptop that's giving you the problems that you are telling us now?
I am struggling with it.
And how are you able to function at Parliament?
Well, half the times I don't. Half the times I have to walk to people for information or call up for information.
Don't you have IT people who can sort out your laptop?
They do sort it out for me regularly. It works for a few days and then it just kicks in again.
I find that very hard to believe, Mr. Adams.
It can be confirmed by Parliament.
I find that very hard to believe.
I would too.
That from October last year, it's only about 3 months back that you became aware that you got a Rule 3 notice from this commission. I find that very hard to believe. Are you telling us the truth?
100%, Justice.
And is this the case also with everything else you received from Parliament? From
Yes.
October last year until about 3 months ago, you did not receive anything from Parliament?
Justice Madlanga, I never said that. I'm saying that the laptop freezes on a daily basis, and therefore if I may, therefore, whenever when I take it out my bag, I normally have to go to IT. It will work for a day or two and it will start again. So
you say you never said what I just suggested to you now. If you did not get the Commission's Rule 3 notice from October until only about 3 months ago, that should be true of communications from Parliament as well. It's on that basis that I've just said what I said to you now.
Yes, Justice, that is what I'm agreeing with you.
So from October, I thought you were saying that's not what you said.
No, sorry. It's not even from October, Justice. It's been for about 18 months that I'm struggling with this device.
Yeah, I'm not concerned about anything else. I'm concerned about October to today. For you to only give to the Commission communication, or rather your statement, which was required from October of last year, for you to only give that statement to the Commission after 9 p.m. last night. And the only excuse you have is that you have difficulties with your laptop. All right. I don't believe that. I find it hard to believe that because otherwise you should not be operational at all as a parliamentarian. Okay, let's move on. Now, about 3 months back, you became aware that a statement was required of you. So according to what you say, which is hard to believe, you have had 3 months and we only get your statement after 9 p.m. last night. What excuse do you have for that?
There is no excuse, Justice, because when I emailed the Commission about 2 weeks ago, I asked for a date. I was given the date of the 11th. I emailed back. I said to them that it is voter registration, 6th, 7th, 8th. I essentially have 5 days to complete this thing. Can I have a slightly later date? The Commission...
Why would you have asked for a date? You would have seen from the communication which you got 3 months back that the statement was required from October last year already. Why would you have asked for a date? 3 months back, you become aware that, oh, for such a long time, a statement was required from me. You still ask for a date instead of saying, wow, I'm very late already, and quickly putting your statement together. Why only a week or a couple of weeks back do you ask for a date only then?
The commission asked me 3 questions, Judge, and I felt that I could offer much more than 3 questions, which is why I asked for a date. When the date was proposed on the 11th, I emailed back, I said, can I have just a little bit more time? And I was told, no, the 11th is the only available date. I moved heaven and earth. I sat up nights to conclude this thing. And I'm not saying that I'm doing that what I did was right. But what I'm saying is I tried my level best to meet the deadline of Thursday. I couldn't.
What I will say, and I will stop here, what I will say is it seems to me that you are not taking this commission seriously. And starting from now and going forward, you should not treat this commission the way you have thus far. Because every and anything you've said thus far is just totally unbelievable. I do not believe it. This should mean that you cannot function at Parliament as a parliamentarian. And it also suggests that you are not even taking the people that you are supposed to serve seriously. If for as long as you suggest is the case, you have been using a laptop that you basically cannot use. You are not taking us as a commission seriously, and I would dare say you are not even taking the people that you are supposed to serve seriously. Starting from now going forward, you must take this commission seriously, Mr. Adams. What do we do now, Mr. Shaskalsin?
Well, Chair, we have the statement. The next open slot, or the next slot that can be made open, is the 19th of August. And Mr. Adams can come on the 19th of August. I'd ask that we postpone to the 19th of August.
Yes. For the record, let me just repeat something that you yourself already said, Mr. Shaskalsin, which is that it is not practical for us to hear Mr. Adams's evidence now. People who follow the Commission's proceedings will have heard that all the time. We refer to what we have read in the statements of witnesses because we prepare ahead of time. If a statement was given or furnished to the Commission after 9 p.m., there is no way that that statement would then be forwarded to us, commissioners, for us to prepare. That's true of the evidence leaders as well, actually, because they too need to prepare. So, practically, it is not possible to hear Mr. Adams's evidence today. For that reason, as Mr. Shaskalsin requests, the hearing of his testimony Mr. Adams's testimony must be postponed. 19
August, Chair.
19 August. Mr. Adams, the hearing of your testimony is postponed to 19 August 2026. You are excused until then. Thank you.
Thank you.
You are excused.
Chair, can I be excused?
You are excused, Mr. Shaskalsin.
Yes.
Let's have a short stand down. We'll hear from you when you are ready to.
Thank you, Chair.
Yeah. Let's adjourn.
Good morning again, Chair.
Yes.
Chair, we're ready to proceed with Ms. Ramsamy's evidence from where we left off last week, Wednesday.
Good morning, Ms. Ramsamy.
Morning, Chair. Morning, Commissioners. Please bear with me. I have a little bit of flu.
Chair, when we adjourned, we were about to start the topic on page 16 of the supplementary statement, which is the Medicare 24 investigation. But I did indicate that the witness was going to provide additional documentation, and some of it does deal with topics that we've already covered. So we just want to address those topics, and where necessary to refer the commissioners to the relevant supporting documentation in support of her statements in her affidavit. The first, Chair, is regarding an issue that Ms. Ramsamy wants to clarify, which relates to the meeting of 22 January 2025, where the first meeting regarding Operation Diversion was discussed, and there was certain references to the National Commissioner not to inform the National Commissioner about the investigation, and in order for the National Commissioner to somehow be caught in a lie, and this was linked to the Portfolio Committee on Policing. And Ms. Ramsamy just wants to give some clarification on what it is that she's saying regarding that aspect, and also that her evidence is not that anyone within the parliamentary committee was complicit in some plan to catch the National Commissioner into lying to the Portfolio Committee. What she seeks to show the commissioners is that this is a discussion that was held within IDAC. It was, as far as she's aware, discussions that were exclusively amongst IDAC members. It may have been that some parliamentary members, Committee on Policing members, were involved in that, but she doesn't have evidence of that. She also wants to deal with the timeline to demonstrate or to just show the commissioners that when meetings were held regarding Mr. Ian Cameron specifically, and certain information that he was going to give IDAC, the very next day his statement is filed and prepared by Mr. Brian Pariachi, who commissions the affidavit as well. So she just wants to put the facts before the commissioners, and whatever conclusions are drawn from that, she doesn't draw conclusions, but the timing of it is significant given that there is this discussion about catching the commissioner in a lie. There's discussion about minutes of meetings, and then Mr. Ian Cameron signs or submits an affidavit, commissions an affidavit on the 9th of April, where he refers to minutes of meetings and he refers to the National Commissioner having misled the parliamentary committee. That's really all that she wants to bring to the fore. And I want to assist her with that because of the documentation that she'll be referring to, and that we can deal with it methodically so that the picture can be fully put out. Because I think when she was dealing with it, she was talking about it within the context of the 2022 January meeting. She didn't really follow through on the thread of that specific topic, so she wants to deal with it now. Ms. Ramsamy, for that, can we go to, the first thing is about the meeting of 22 January 2025 and the ID initiating that meeting. We initially didn't have the email from the ID calling on that meeting. We do now have that, Chair, and that should be at file 10, page 419. I think it's called file 10-2. Yes, file 10, part 2. Page 419. Ms. Ramsamy, do you have the email?
Yes, I do.
And this is an email on the 16th of January 2025 at 8:51 from Advocate Johnson she copies herself, she sends it to herself, Mr. Perumal, Mr. Sesoko, Mr. Rapesu, and you, and she CCs her PA, I think it is Ms.
Correct.
Ino, who you refer to as Ino. Now, the subject is diversion. When is the reference to a meeting that's to be held on Wednesday, January 22nd from 12 till 2:30 at the SARS Boardroom 2.2. Can you read the message?
Dear colleagues, I want a full briefing. Who did what? Who have you seen? What are you dealing with? Kindly prepare a presentation and make sure my office receives it no later than Monday the 20th.
Okay, and so that is the meeting that gets called on the 22nd. We know that Mr. Perumal submits a draft presentation, which we've been through. You also work on that presentation at the prosecutorial input.
Correct.
And submit that to Advocate Johnson and Mr. Sesoko on the 19th of January in preparation for that meeting.
Correct.
Now, insofar as whether Advocate Johnson had any input on that presentation, do you know whether she did?
She did. Advocate Johnson, at the presentation on the 22nd, I had printed a version, her edited version of the presentation with her input and her additions and subtractions, and had given us hard copies, whereas Mr. Perumal and myself had submitted soft copies via email.
Okay, so Advocate Johnson worked off the version that you gave her, and did she send it to the team or just presented hard copies on the day?
She presented hard copies on the day.
Okay. Commissioners, we have been given a copy of that actually the original with Advocate Johnson's manuscript additions made onto the version that she gave the members on the day. So she was aware of what was contained in the presentation before the presentation started on the 22nd of January.
Correct.
Okay. Now, you then testified about what happened in that meeting, and specifically in reference to file 11, page 5, which is a note by you about the National Commissioner, file 11, page 5, which is the handwritten notes.
Yes, Advocate Johnson made specific or made a specific statement saying...
Can we just get to it first then?
By 11 page?
Page 5. And that is the note. Your evidence was that during that meeting, Advocate Johnson then said, we're not going to tell the National Commissioner about the investigation so that he can be caught in a lie should he appear before the Parliamentary Portfolio Committee on Policing.
Correct.
Okay. Now you later...
And this is your note. Is it her note?
No, I'm writing down what Advocate Johnson is saying in the meeting.
Thank you.
We'll come back to the reference to the IGI again later, but then later in your evidence, you also testified that there was a discussion between you and Mr. Perumal, and you said somewhere in February or March, where he mentioned that the National Commissioner will be appearing before the Portfolio Committee soon, and he'll commit perjury or something to that effect.
Something to that effect, correct. It would have been either the 9th of February or the 28th of March. It was one of those two conversations. But in my recollection, I think it was closer towards April. So it would have been around the 28th of March, where the conversation was, he's going to lie and it's going to be a perjury charge at the Portfolio Committee, him being NASCOM.
And just to be clear, that was a discussion not with Advocate Johnson, it was with you and Mr. Perumal.
Correct.
Okay. Commissioners, there is a reference to that evidence that the witness gave on the 5th of August on page 119 of the transcript, which I just had a look at. And what she says is, it's in response to Advocate Baloy's question about before you leave your note at page 5, did Advocate Johnson say why the National Commissioner should be left to lie? What was the plan, the idea behind let him go lie to Parliament, and then what? And then Ms. Ramsamy says, like I said in Statement 1, Commissioners, it looked and obviously became evident that there was a line of march, and that line of march was to get General Khumalo and General Masimola in an accused box. And so obviously at some point there was talk about if he lies at Portfolio Committee, and this was again well after. I think this is the February or March, and this was just between Yusei Pariachi and myself and Mr. Perumal, where if he lies we can at least charge him for perjury. So the clarification that I want from you is that Advocate Johnson didn't mention anything about the Commissioner being charged on perjury in January 22, at the 22 January meeting. The perjury issue arose in the conversation that you had later on with Mr. Perumal.
Correct.
Okay.
Advocate Johnson's words were, don't tell him, let him go lie. That was...
Morning.
Morning.
Can I just
Commissioner.
clarify something? For the plan to work, they must have known what the National Commissioner was going to be asked, or what was going to be discussed with the National Commissioner at the ad hoc. And they must have known that if he gives a certain answer, it will be untruthful and could lead to adverse consequences. I mean, how did all that work? I mean, how did they know that he will go there and he will be asked a certain question, and if he gives a particular answer, it will be a lie? How would they have known that? Because this is January 2025. It's very early in the year.
Commissioner, I also had those questions, and I did earlier, I think it was on my evidence on the 29th of July, where I said that Advocate Johnson, Mr. Perumal and Mr. Padiachi would speak in undertones. They would understand what the other person is saying, and the rest of us were left to catch up. So when I analyzed the January conversation or statement by Advocate Johnson, and then the later conversation with Mr. Perumal, and then the consultation or the meeting that took place between myself, Mr. Perumal, and Mr. Padiachi on the 8th of April. I then put through the link that there was communication between IDAC and the Portfolio Committee, or certain members of the Portfolio Committee. I'm not saying that I have concrete proof. I'm saying that it's the inference that I drew.
Now, can we go then to file 11, page 16? And perhaps if we start at page 13, because this will show us that this was the meeting at Fire and Ice. On page 13, 2025/4/8, and it's D, B, and me, which is Mr. Perumal, Mr. Pariachi, and you.
Correct.
Okay, and there's various discussions about the operation, but if we can go to page 16, you will see there's another note on there's a page 16, it says Ian Cameron, and then it says minutes.
Correct.
Okay. And do you recall what you were recording there insofar as minutes and Mr. Cameron?
If I had been given detail, I would have written it down as per the remainder from page 13. It's very clear I was writing pretty much everything down. It was a brief passing conversation that said they were seeing Ian Cameron to get the minutes. And this was on the 8th of April. If anything more was said, I would have noted it down, but that was basically what was said.
And those minutes, would those have been minutes of the Portfolio Committee meeting?
I later found out that it was the minutes of the Portfolio Committee as per the Mr. Cameron's statement on the 9th of April.
And they didn't say why they got the minutes of that meeting from, or they would be getting that the minutes of those meetings?
At this point, Commissioners and Chair, I was distrusted. I was not kept in the loop. And I explained that at this point they only gave me, there's a saying, you keep a mushroom in the dark and feed it. So it's basically, they were using me to enroll the Lushaba matter, and that was the purpose. And I read the WhatsApps on last week where on the 5th of April, Mr. Perumal called me to say that this is an urgent meeting, it has to take place. And that is why I drove to Fire and Ice to have the meeting with him. So it's a possibility that they didn't even want me to know about this. It just happened and it came out.
And when you were asked about the meeting, or to attend a meeting on the 5th of April, the Portfolio Committee meeting had taken place on the 2nd of April.
I did Google last week after testifying. Yes, it did take place on the 2nd of April.
If we can go to file 7, which is Mr. Cameron's statement at 2820. Page 2820. And while we're getting to that statement, do you know why Mr. Cameron prepared this statement as the A6?
No, I do not. I also found it unnecessary and irrelevant.
Do you know for which matter it was, for which case?
If memory serves, it was in the, it was for the purposes of the Mokwele matter and for the arrest of what they called the Khumalo Masiamula matter.
So
and
the
then also the
appointments
Khumalo Madondo matter. So yes, the appointments.
relating
and the
to
vetting.
crime intelligence appointments.
Correct, and the vetting of those persons appointed.
Can I just ask, do you know from those minutes whether the Mokwele, the vetting issues were discussed in that portfolio committee meeting?
As the
Because when you look at paragraph 10, he ventures that he believes they have lied, or that many
Yes,
they've lied. Do you know if there was such a discussion?
To date, the prosecutors have not received those minutes.
Oh.
If I can refer you to paragraph 5 of the statement at 2820, that's where he mentions that as chairperson, I convened a portfolio committee meeting on Wednesday, 2025-0402, which would be 2 April 2025, online with members of the committee, senior managers from the Office of the Minister of Police and senior management of the SAPS, led by General S.F. Masimola. And then on the next page, 2821, paragraph 6, for ease of reference, I attach here to the audio recording, video recording and minutes of the said meeting, which includes replies to questions posed by committee members and the replies thereto by SAPS senior management. Then, so he does say that he's attaching the video recording and minutes, but you say you haven't seen those minutes and you haven't seen a report.
The investigators, Mr. Padiachi and Mr. Perumal, have not provided it to us.
Okay, and you don't know if he did in fact provide it. I mean, it's referenced in his statement, but we don't know if he actually did provide it.
No, I cannot confirm that he provided it.
We know Mr. Padiachi took the statement in Cape Town on the 9th, so he would have presumably given it to him if he did. If it was provided, or it would be annexed to the statement.
It should have been where it says paragraph 6, I annex here too. It should have been marked as an annexure too. And generally it would have been either in a sealed envelope or in an exhibit bag for it to be annexed to a statement.
Can I just ask a process issue? When IDAC receives documents, such as a statement and annexures and any other document, is there not a system of recording what has been received and from whom?
In all other projects, yes. there is a system in place. In all the other projects I've worked on, except for these two that I'm discussing, there is a system in place.
Thank you.
And then at paragraph 7, Mr. Cameron says, there have been several media press releases and on social digital platforms where allegations of corruption within the Crime Intelligence Division have surfaced. The committee was therefore focused on addressing some of these allegations, as will be evident from the minutes. So again, there's a reference to the minutes. We know in your note on the 8th of April, there's a discussion about minutes from Mr. Ian Cameron.
Correct.
But we don't know whether those minutes were actually provided by him. But we do know that on the 8th, before the statement is made or commissioned, Mr. Perumal is referring to Ian Cameron and minutes.
Correct.
Okay. Now, at paragraph 8, he says some committee members were not satisfied with the SAPS management responses. However, in the absence of factual evidence, I intervened and closed the agenda point and moved to the next item on the agenda. And at paragraph 10, he says, I suspect the senior management of the SAPS, led by General Masemola, misled the portfolio committee in answer to several questions posed to them. To confirm exactly where the committee was misled, it will be prudent for the committee's recording of the meeting to be compared with the evidence available in the relevant crime intelligence files. Do you know what crime intelligence files he is referring to?
I would, my understanding of that would be the dockets that IDAC was in possession of and investigating.
But when you say dockets, are you referring to Mr. Adams' dockets, or are you referring to the contents in that dockets that contain crime intelligence files? What are you referring
contents.
to? Okay.
But why only dockets? I mean, I would imagine crime intelligence should have a whole lot of documents on a variety of issues that might have been relevant to what was being raised by the portfolio committee, but not only or necessarily dockets.
It's open to interpretation, and I think the deponent would be best suited to explain. But with regards to evidence available in relevant crime intelligence files.
But do you accept the wider possibility that I'm positing to you?
I do.
Thank you.
Okay.
Ms. Ngube, does this not refer to vetting? Are these not vetting files that are not being referred to?
Well, we don't know, Commissioner Khumalo. I mean, he speaks about appointments. I think it is, but we don't know
That's
what
why I am asking the question, because if it talks about crime intelligence files, and then it can relate to the dockets that Mr. Adams opened.
Yes, I mean, the witness doesn't know. She was just, I guess, offering, but you don't know.
No,
and
I cannot confirm.
Do you know whether Mr. Cameron gave Mr. Perumal or Mr. Pariachi any crime intelligence files?
No, I don't.
And
save for this affidavit, we didn't even receive the minutes.
You didn't see the minutes in the docket where this statement is supposed to be, because this statement is labeled A6, which means it's part of a docket.
My understanding is that this is A6 in the Mokwele matter docket.
Okay, so it's A6 in the Mokwele docket, and so therefore if there were any documents that emanated from the statement or were included with the statement, it would have been in that docket.
Correct.
And you didn't see any crime intelligence files in the docket?
No. I had explained previously that we were working off digital copies of the docket, and when I was perusing the docket in June to make an evidential assessment, it was the minutes were not there.
Okay. And the recording as well, not in?
No, there was nothing.
Okay.
Can I just ask, still again, in a way it's a process issue. At this point, are you the prosecutor in charge of the matter?
At this point, it's now myself and Advocate Schlatzweiler.
Okay. And as the prosecutor, when you receive, and my question assumes that you received this affidavit at the time, around the period that it was taken. It's not something that you see now, today, as you're testifying.
On the 19th of June, I received it, yes.
Okay. Do you not ask where are the annexes? Because I assume you read the affidavit when you get it. It's part of, you say it's part of a docket that you're going to receive, that you're going to be discovering. On the face of it, clearly, without the annexes, it's incomplete, and so you're going to be discovering an incomplete set of documents if this is what all you're discovering. Don't you, as a prosecutor, say, where are the annexes? We have to see them, but more importantly, we need to disclose them. What happened here?
Ordinarily, we would. If I may just digress as to what happened around that period when I received the docket. Ordinarily, we would, but on the 19th of June, 2025, I had received the electronic copy. I had read the docket, and I found that there was no merit for enrollment. I found that there was no prima facie case. So I had started preparing a memo, because irrespective of this statement, the other statements held no element of an offense, or spoke to no offense that could be taken to court, so no prima facie case. So I had started drafting a memo, which the commissioners will see shortly, where you go statement by statement, problem by problem, and then submissions. And you would recommend that there's no prima facie case. Unfortunately, I came down with bronchitis. Severe bronchitis. I was actually going for physio to loosen the phlegm in my chest. And I didn't finish the memo. While I was on sick leave, I received a call from someone in the office, and then a WhatsApp saying, hey, aren't you dealing with the crime intelligence matters? Your matter's in court. And when I put the TV on, I see that the Mukwele arrest has taken place. So it was a matter of, I was in the process of doing the memo, and had I not been sick, I would have completed and submitted the memo.
You would have asked about.
I would have made reference to the fact that these things are not in the copy of the docket that we received.
Thank you. Thanks, Mr.
Mr. Obe, the reason why I thought this has to do with the vetting issue and specifically the Madondo issue, because the statement is A6, but if you go to A1 and A2, A3, A4, A5, 2611 is the A1, followed by the Adams affidavit relating to the lateral transfer of General Madondo, and then they follow in that sequence. So even the affidavit before Mr. Cameron's is the affidavit of General Khan, which also talks to so it's not the Mukwele issue, it's the vetting issue and the Madondo issue, the way it looks to me, and I could be wrong, but the sequence of documents suggests that it relates to that transfer of General Madondo. And the Cameron statement, Mr. Cameron's statement, in that paragraph that we were looking at, where he talks about relevant crime intelligence files, it must be referring to that subject.
Do you want to comment?
It's a possibility. However, I do remember seeing Ian Cameron's statement in the Mukwele docket. I stand to be corrected, but memory serves that it was, in fact, in that docket.
And when you had the discussion with Mr. Perumal at Fire and Ice, when you had that meeting, if you go to page 13, you were discussing all the matters, basically. It wasn't just the vetting matter.
You're talking about the 8th of April?
Yes, on page 13.
If you look at the notes, it's predominantly the housebreaking matter.
Okay.
It's Lushaba's matter predominantly until such point as you reach page 16 where the Ian Cameron pops up.
And was it, I mean, you weren't really involved in that process. One of your complaints was that you were not being included or being informed when consultations were being held with witnesses or any person related to these cases that you were involved in.
Correct.
And so when you get told that Mr. Cameron is going to provide minutes or there's a reference to minutes, what is it? Do you say anything to them? Is there a discussion about it? Are they mentioning that they're busy getting a statement from him?
No, I didn't ask any questions because I could see that they were uncomfortable that the name was mentioned, and it stopped there.
Okay, and then we know that on the 9th, when the statement is then prepared, there's the WhatsApp conversation where there's an indication that Mr. Cameron had submitted his affidavit, was busy with his affidavit.
Correct.
And that was from, it's a conversation between Mr. Perumal and Advocate Johnson, which he sends to you.
Correct.
Okay. Is there anything else you want to address on that issue related to Mr. Cameron's affidavit?
It's safe to say that I didn't say that he was part of the narrative or he had included himself in the narrative. My statement was very clear. The inference I drew from all the events that transpired leading to his affidavit and me being informed about his affidavit, as well as the fact that there's a message between Mr. Perumal and Ms. Advocate Johnson indicating that he's on board. So the inference I drew was what I stated.
Okay. Then can we move on to the next topic where we just have to close out? It's the Section 28(1) authorization on the Mokwele matter, which is where we finished off your evidence last week where you indicated that you didn't prepare that authorization. Following on that evidence, I had asked you to go and look at your emails to see if you had ever sent Advocate Johnson any Section 28(1) authorization in May. I think I asked you to look for that specific, whether in May you had sent a 28(1). We know that you sent the Matlala, the Medicare 24 Section 28(1) application, but I asked you specifically to go and look for the Mokwele or any crime intelligence matters, and you weren't able to find any emails.
From May, no.
Okay. And we then tried to establish where the date of the 30th of May could have come from, given that you had only sent the, what you refer to as the umbrella Section 28(1) application on the 3rd of June.
Correct.
And Commissioners, the witness had previously sent us the trail of emails between her and the project manager where he mentions the Section 28 authorizations, but she sent us the last email in the chain which wouldn't have an attachment. So we've asked her to send each email individually, and when she sent the first email, there were attachments, and we would like to deal with that now. And that is in file 10. If we can go to page 548.
Part 2 or the old 10?
Part 2.
Part 2.
10, yeah, 548, part 2.
Thank you.
File 10, part 2. So at 548, at the bottom of 548, there's an email from Mr. Tlale to you and to Advocate Hlashwayo on the 16th of July 2025 with the subject Section 28 authorizations, and he says, "Hi ladies, these are the soft copies of your authorizations." And if we go to 549, we see that there were 6 attachments.
Correct.
for 3 documents for leg 1 and 3 documents for leg 2. Do you recall why he sent you these soft copy authorizations in July 2025?
No, I was actually confused, and I did reply to this email.
Yes, we'll get to your reply, but can we then go to page 550, which is one of the attachments to that email? And Commissioners, what you will see there is Advocate John, it's a document from Advocate Ramsamy to Advocate Johnson dated 30 May 2025, and you'll see that the subject relates to the authorization of diversion leg 1, housebreaking burglary. And this is now where we see the date of 30 May 2025.
Correct.
But this, you had sent an umbrella Section 28 on the 3rd of June, and what you get back in July 2025 is a split Section 28(1) application.
Correct.
Did you prepare this document?
No.
Okay. And if we go to 563,
Which document did you not prepare? The one at 550?
550 was not prepared by me.
at 563, there's another document, also with the same 30 May 2025 date, which is then an application for 28(1) for leg 2, which is the appointment, which is the Mokwele matter.
Correct.
Okay. And this was one of the attachments from Mr. Tlale.
Correct.
Did you prepare this document?
No, this was not prepared by me.
Who prepared the one at 550 and this one, the one at 558? Who prepared them?
The emails confirm that the project manager, Mr. Tlale, prepared them.
Okay. Can we go to page
Can I just-
517? Oh.
Was it unusual that the project manager would prepare a document for you and then such as this and send to you, because he prepares it and then he sends it to you, I suppose, for you to approve or not to approve? Was it a regular occurrence? Or
No.
is there anything unusual
It's
in the
very
fact
unusual.
that he's done it this way?
Commissioner Baloyi, if we go back to how I was explaining how the process works, it would, I even spoke about the formatting, if you're good with formatting. It's usually prosecutor to DD to project manager to submit to Advocate Johnson. Or if you're not good with formatting, then you would send it to the project manager, as I did on the 3rd of June, for him to format, send back to me, and then it would be submitted. But these documents are not supposed to be done by the project manager.
And that is what you did on the 3rd of June when you sent him your draft with the umbrella section 28(1). You sent it to him and said, please work your magic.
Correct.
And you explained to us that he had to do the formatting.
Yes.
You didn't expect to get a month later 2 28(1)s that refer to leg 1 and leg 2.
Correct.
Okay. And in fact, Advocate Johnson's email on the 3rd of June was saying that she's still working on the section 28 that you had sent her.
Yes.
Okay. And that one had a date of 2 June 2025. It wasn't 30 May.
My apologies. Yes, correct.
You then responded to the email from Mr. Tlale, and that we find on page 579.
My apologies. 579.
Yes, we'll have to read it from the bottom to the top. So at the bottom of the page, we have Mr. Tlale's email where he says, hi ladies, these are the soft copies of your authorizations. And then the email above that, it's from you to him, section 28 authorizations. You say, hi, are these signed? Who did them?
Correct.
Because what you get sent is unsigned 28(1)s.
That I
Well,
did
all
not-
the documents are unsigned.
Yeah, which I did not compile, nor did Advocate Hlatswayo compile.
And so you're asking him who did them.
Correct. I wanted to know, are these signed and who did them?
And his response then to you is the email above that. He says, only leg 1 is signed, which means only housebreaking is signed.
Correct.
I compiled all using your prosecution memos. I need to fix leg 2 as per ID.
Correct.
And leg 2 is the Mokwele matter.
Correct.
And so, as at 16 July 2025, he's saying that he still needs to fix the 28-1 in respect of the Mokwele matter, as per the ID.
Which then confirms that as of the 16th of July 2025, there was no 28-1 authorization for the Mokwele matter.
Did you have a discussion with him about it?
I did, and I asked him, I went to his office and I asked him, why is Mokwele in my name? Why is it being submitted in my name? I was on sick leave and now you're submitting a document in my name where I'm not the prosecutor anymore and another prosecutor enrolled it. And he just did.
Know why the prosecutor, Ms. Hlajwayo, is copied on these emails?
Because she's the prosecutor that enrolled Mokwele.
And this is almost a month after the arrest.
Correct.
Ms. Seegers, Ms. Ramsamy said when she asked why this document was submitted in her name, he just did this. Do you want to describe
I
that
don't know what to say,
place it on record?
He shrugged.
You shrugged.
He shrugged.
He shrugged.
Yeah.
He lifted his hands in a manner that, was indicative of shrugging.
Correct.
All right, okay.
Okay. And have you, apart from what was flighted at the Commission, which was the 30 May 2025 application and authorization signed by Advocate Johnson with a date 30 May 2025, have you ever seen a Section 28(1) authorization for the Mokwele matter other than the one that was displayed here?
No, there was no signed 28(1) for the Lushaba matter or the Mokwele matter that has been provided to myself or Advocate Hlatswayo.
What was provided by Mr. Tlale sometime in November 2025 was the signed Section 28(2)A authorizations.
Correct.
For both matters.
Correct.
And those are dated?
8 August 2025, and a Section 28(2) is in terms of the Act, it's sort of like a certificate that Advocate Johnson would sign to allow us to prosecute on behalf of the ID. So even that should have been signed prior to.
Can you just explain
Prior to the arrest, you mean?
Prior to the 13th of June and the 25th, 26th of June? Yeah.
Can you just explain where does the 28(2)A fall in the process and who prepares that document? Because I haven't seen any draft from it. Is it just something that Advocate Johnson sends?
With the 27 referral from 2023, I drafted the 28(2) and submitted it for authorization after my deputy director approved the drafting and the contents. So it should have come from the prosecutors.
And that document, is it part of the legislation that there must be the 28(2)A, or is it something that's a practice or procedure in the SOP? Where does it come from, and why do you need it?
Sometimes Advocate Johnson would ask for it, sometimes not. But with the 27 referral, she would. In terms of the Act, Advocate Johnson needs to delegate authority to prosecutors, either deputy director, senior state advocates, to prosecute on behalf of the investigating director. And that is the purpose of a 28(2), to provide us with a certificate to authorize us. It's the same thing as a delegation. So if I was a district court prosecutor and they gave me an acting stint in the regional court, the DDPP of that jurisdiction would issue a certificate of delegation to allow me to prosecute in the regional court. So it's a delegation for us to have permission to, or authorization to prosecute.
We're going to include it in the...
Within IDAC, is this done once off or is it done per matter?
Like I said, Advocate Johnson, because of the 227 referrals, the first one I knew that I was requested to do one. And so it was the deputy director and I were trying to figure out how to format it and how it was supposed to be worded because we didn't have an example. But it became a standard procedure later on. But like I said, standard procedures were deviated very often according to what Advocate Johnson wanted at the time.
What I'm trying to understand is the delegation to prosecute. Would that not be done once off? Because for that to be a delegation each time a matter comes up, it sounds quite cumbersome. So would it be a once-off delegation? Or?
We are issued with a delegation. I think we've been issued with 3 different ones now. With Advocate Johnson, it's a certificate that we generally carry with us just in case either a judge or a magistrate wants to see. But that is done, if memory serves, it's done in terms of Section 24 of the NPA Act, not in terms of Section 28.
Okay.
Can I just clarify? And it may be a difference of practice and what the law prescribes. A quick look at 28.2 is authority to investigate, not to prosecute. Were you using it differently?
I'm trying to find my NPA Act. In our exhibit file, do we have the 28.2?
It was there at some point, I'm not sure. NPA Act?
Have you found it? I see you are paging. Have you found the Act?
Section 20.
No.
Can we display it in front of you? You should be able to see it on the screen in front of you. Display.
And whilst you are looking, in any event, with regard to a delegation to prosecute, as I understand it, you and other prosecutors are part of the NPA anyway. So it would make much sense for there to be a new delegation to prosecute, as it were, if you already have a delegation to prosecute. But please respond directly to the question by Commissioner Baloyi.
Correct. It is to investigate.
Thank you.
Okay. We'll include the email chain regarding the 28.2As in the bundle. For now, we'll just display it. It's an email from Ms. Lachwayo on the 12th of November 2025 to Mr. Tlale, copying you, where she's responding to his July email where he says these are the soft copies for your authorizations. She sends an email to him saying, "Good morning, Tsepo. I have just realized that Brapita is not designated in these matters, more especially leg 2, and currently is the one who is appearing in court. May you kindly add him?" And his response is above that. He says he is. Please receive attached. And what he attaches, if you look at the 3rd page, is the section 28.2A designations, 8 August, you'll see the date is 8 August 2025.
Correct.
And we do have the attachments. The first one, you'll see once it comes up, it again refers to, in the first line, whereas I, Andrea Johnson, the investigating director, on 30 May 2025, have decided to conduct an investigation in terms of section 28.1A. Again, there's reference to the authorization, which you know nothing of, for 30 May 2025.
Correct.
And was November 2025 the first time that you saw this 28.2A?
Yes, it was the first time that it was emailed to us.
If you look at the third page, it's got the signature date of Advocate Johnson. It's 8 August 2025.
Correct.
Okay. And insofar as the 28(1)A authorization, so we've spoken about the application for authorization. Have you seen this signed, other than the 30 May 2025, that's part of the bundle that was displayed during Advocate Johnson's evidence? Have you seen an authorization for the Mokwele matter other than the 30 May 2025 one?
I saw the one that I sent that wasn't signed on the 3rd of June, and then these, but a signed one from Advocate Johnson was never submitted to us.
28(1).
Correct.
Okay. Only the 30 May 2025 one that was displayed here at the Commission. Now, then if we can move on to another topic insofar as the Mokwele matter is concerned, and this relates to the evidence of Advocate Sarunye regarding the bail amendment and bail application, bail appeal proceedings from September 2025.
Correct.
Now, his evidence, insofar as we know that you were involved somewhat in that process, but you were no longer the prosecutor on the Mokwele matter, or were you still with Ms. Latshwayo?
No, on the 8th of August, Advocate Johnson had separated us completely on the matters. However, with regards to the bail application, I was asked by Advocate Sarunye to assist.
Okay, and just to recap that Advocate Sarunye gets involved in August.
Correct, on the 8th of August.
Well, he was at the first appearance in June, but then his real involvement starts in August 2025. He then sends his trial preparation memo where he raises pertinent questions regarding the case, and your evidence was that when he got involved, there was a voice that you could now go and speak to, somebody that would hear the complaints about what your assessment, you and Ms. Latshwayo, your assessment of the matters are concerned.
Correct.
And he seemed to hold the same views.
Yes.
We know that Mr. Perumal responded to his email, but you didn't respond to his email where he had raised all those questions. And you were copied in on that email, you and Ms. Latshwayo. Can you tell us why you didn't respond?
If the Commissioner and Chair would note the times of Mr. Advocate Sarunye's emails, it was generally towards the latter part of the afternoon or evening. During the day, Advocate Latshwayo and myself would sit with Advocate Sarunye in his office, and we would dissect all of these things, and we would voice our concerns, and he even testified to the effect that they were not listening, the investigators were not listening to Advocate Latshwayo and I. So that is why when I testified on the 29th of July, I said when Advocate Sarunye started listening to us and taking these things up in writing and asking for answers, it gave us a sense of relief. With regards to the bail question, I was assisting due to Advocate Sarunye's health. So we needed all hands on deck. But there are messages with regards to how that transpired.
Yes, we'll get to those messages. I think the first event in that sequence is a meeting that was held on 1 September 2025, which we'll file in file 11, page 74. Chair, perhaps before we continue with this topic, it's maybe best to take the tea adjournment, and we'll continue when we get back.
Let's resume at 11:30. Let's adjourn.
11. We are ready to resume. Please make sure your cell phones are off. Thank you.
Thank you, Chair.
Yes.
Just before the adjournment, we were at page 74 of file 11, which were these are your notes of a meeting held on the 1st of September 2025, and I had asked you what was the purpose for this meeting.
Advocate Johnson was unhappy with Advocate Serunye's questions and his emails and his questioning of whether these matters fell within IDAC's mandate. She was upset about the constant request for the 27 referral. So Advocate Johnson chaired the meeting while Mr. Perumal and Mr. Padiachi joined on Teams. Sorry. Advocate Johnson seemed to be upset with Advocate Schlatzwayo and myself as well in indicating that we had not explained to Advocate Serunye the overarching purpose of the crime intelligence matters.
Which she said was what?
Racketeering and state capture.
And did she explain the state capture aspect?
She addressed Advocate Serunye trying to explain that the Mukwele arrest was similar to that of the Celebi judgment and that of the Zuma Sheikh judgment. There was disagreement about that because in those judgments, it was clear what the quid pro quo would be, even though there wasn't a specific agreement. And yes, the gratification or the quid pro quo would come in effect later on, but it was evident from the relationship what would be expected, versus the Mukwele matter where it's just a mere statement of in the future. In the future to do what? So that was the to and fro's that were happening. However, Advocate Johnson then got agitated and took over and wouldn't allow us to speak and laid down the law that these matters are going to proceed and that the investigating officers are going to explain to the prosecutors what the evidence is and how we should interpret it and understand it and prosecute it.
So it was in effect to persuade Advocate Serunye that there was a case on the Mukwele matter, or were there other matters discussed?
There were two other matters discussed. In my statement, I later deal with the Madondo Khumalo and the Masiamula Khumalo arrests, which are two separate issues. Advocate Johnson in that meeting indicated that irrespective of what Advocate Schlatzwayo and I had presented to her in July already, those matters will be enrolled.
And we see there you have 3 bullet points. The second bullet point on your note says CI IDAC equals is the state capture. And then the next bullet, circumvented in an arrow in anticipation of. What was she discussing there?
Advocate Johnson was telling Advocate Serunye, Advocate Schlatzwayo and myself that the crime intelligence investigation done by IDAC is actually state capture, and that's the reason IDAC was created, formed, and that these matters, these specific matters, were state capture. And she kept repeating state capture. With regards to circumvented, she's speaking about the promotions and the ads being withdrawn with regards to the Mokwele matter and then re-advertised externally. So it circumvented meaning that, and it was in anticipation of. And then there was an explanation that Brigadier Mokwele's father works for the Hawks and that he was charged for trying to bribe another official.
What was said to be the relevance of her father's employment in the Hawks and being charged?
What was they were trying to explain here was that the quid pro quo would then be equated to the fact that General Khumalo was giving gratification to Brigadier Mokwele's father by appointing her.
And there's a reference to, it says, there's a docket that relates to her father, and then it says uncle and Labia. What is the reference to Labia? That General Labia?
Yes, there's a docket that relates to her uncle. It's supposed to be a slash or father, and the docket is with General Labia. Or they're going to obtain the docket through General Labia.
And if we then go to page 77.
Ms. Mobe, before you leave that page, the entry at page 74 still, the entry right at the top, what is that about? What does it say?
The first entry with the dot under the names, and we need to finalize the charge sheet, Khumalo matter.
And that's a different matter to the Mokwele matter?
It's the same matter. It was referred to as the Khumalo matter, or we referred to it as the Khumalo matter, being myself, Advocate Hlatswayo, and Advocate Sirunya.
And this is on the 1st of September. It's a meeting on that. So at this point, there was no finalized charge sheet yet, and yet they have been arrested. Can you just explain what happened?
After Advocate Sirunya came on board and he was listening to us and we were explaining that there's no crime of corruption, he also picked it up when he read it. And that's how the second charge sheet, it was at this point that the second charge sheet of Section 21, conspiracy, was drafted.
What Advocate Sirunya referred to as the amended charge sheet,
correct.
Is that what you're referring to?
Yes, correct.
I see. Thank you.
And on page 77, there's another entry in reference to the charge sheet. So at the bottom of the page, just before the arrow that says Mokwele's docket, it says, I can't see the first word, it says just have to beef up charge sheet in equal corruption. 77.
We just have to.
Do you see it? Yes. Beef up charge sheet, equal corruption, Mokwele's docket.
So part of the discussion here was to beef up the Mokwele charge sheet to the corruption charge in the Mokwele charge sheet.
With regards to this conversation, it was more the investigators telling the prosecutors what evidence is there to beef up the charge sheets to prove corruption.
Okay, and then if we, because we have dealt with this aspect quite extensively on these discussions, I want to go to a different aspect that was discussed at that meeting on page 80.
Yes?
Sort of towards the end of the page, there's a reference to IGI, page 45 to 75, part 2 report.
Correct.
What is that?
Commissioner Beloy asked me a question last week about IGI, whether an IGI meeting took place. So in order for us to understand this paragraph, I need to explain the first meeting and then this. So in January, Mr. Sissoko arranged for a meeting at IGI. We had a meeting with Advocate J. Govender and another member of the IGI legal team. Where they indicated, yes, they were tasked to do an investigation, but they cannot share their findings with us because of their mandate and the fact that they are regulated by a different act. And their reporting lines are very different. So, in essence, there was some words exchanged. So Advocate Govender was addressing me through the meeting. We were discussing, I asked her how many different crime intelligence matters, etc. So she did indicate that they are in the process, they are consulting with witnesses based on certain complaints. She was unable to give me any witness names. She explained safety as well as different mandates. So Mr. Perumal got agitated to a point where Advocate Govender even said to him, your cowboy tactics is not going to work on these cases. We left that meeting. I did say it was a fruitless meeting because we couldn't assist them and they couldn't assist us.
Sorry, you couldn't and they couldn't assist you. What was the purpose of the meeting when you went there?
With IGI, like with other investigations that had been completed previously during the Zondo Commission period, they are able to assist because the report has been completed. But because this was still in the process of investigations, sharing of information could not take place. So, Commissioner and Chair, we left that meeting and Mr. Perumal then wanted to arrest Advocate Govender for Section 34 for not willing to assist us. And there was this whole thing where I had to pull out the IGI Act and explain to him that they have their own. But that's just on a side note. But it was just to give you an explanation of how things were being done.
Can I just interject there? So this is the meeting that Mr. Sissoko also testified about that he attended.
Correct, in January 2025.
And did you obtain any documents at that stage?
No, nothing was shared with us.
And the discussion was about crime intelligence investigations, current investigations that the IGI was investigating?
Correct.
Okay.
Based on complaints that they had received.
Okay, so you leave that meeting and you did report back to Advocate Johnson saying that it was a fruitless meeting, and she says she's not surprised.
Yes, correct.
Okay. And then we now in September.
So we in September, and Mr. Perumal is explaining various things about how Advocate Schlatzwayo, Advocate Seruni, and myself are not understanding the evidence of the Mukwele docket. He then tells us that the minister, being Minister Mkunu, arranged for someone to fly to Eastern Cape to him and provide the IGI reports.
And this is the IGI report that was prepared in respect of the crime intelligence investigations undertaken by the IGI.
Correct.
Which you were told at the time in January they were still busy with investigations.
Correct. And my understanding of those reports is someone very high up has to approve that we share that information.
Okay, so what Mr. Perumal communicated in that meeting was that Minister Mkunu arranged for someone to fly that report, a hard copy of that report, to Mr. Perumal in the Eastern Cape.
Correct.
And the IGI had given that report to the minister?
Correct.
Okay. And in terms of what legislation or powers did the IGI give that report to the minister? Was there an explanation as to, was it commissioned by the minister, report commission or investigation commissioned by the minister?
It's unclear. I just know that that report was not supposed to come to us in that way.
Okay, do you know, it wasn't supposed to come to IDAC?
IDAC.
Via the minister?
Correct.
Okay, and why do you say that?
Because the IGI, I had read the act prior to going to have the meeting with Advocate Governor.
In January?
In January. There's certain procedures and processes that must be followed in order for that information sharing. I had also spoken to Advocate Lowe, the Deputy Director who's retired now. He was dealing with a matter that IGI and him, or that team, were sharing information. There were channels that had to be followed in order for that information to be shared.
And did Mr. Perumal say whether Advocate Johnson was aware that he had gotten the report from the minister?
Yes, in my notes, there's, in one of the notes, there is note, just a note down that says Dylan must call IG. But in this meeting, Mr. Perumal indicated very clearly that the ID is aware that the minister has arranged for this report to be flown to me.
Okay, I'll ask you to find that reference during the lunch adjournment, but for now, so that is what he tells you about how he got the report.
Correct.
And does he say anything else about the report in that meeting? Because you have a reference that says page 45 to 75. I would assume that's page 45 to 75 of the report.
Correct. It's even part, he's even telling us which part of the report is relevant. Mr. Perumal then WhatsApps me the IGI report.
If we can go to page 600 first, and you tell us why you took a photograph of this. File 10, part 2. This is a photograph of a letter dated 2 April 2025 addressed to the minister.
Correct.
And it's on the letterhead of the Office of the Inspector General of Intelligence. Before you read the letter, can you tell us why you took a photo of this letter?
I sent it to the evidence leaders to show that we are in possession of an IGI report and all the correspondence, or the correspondence that's attached to it.
Okay, can you read the letter into the record, and then I'll ask, then we can go to the WhatsApp where you received the report.
It's addressed to Minister E.S. Mchunu, MP, Honorable Minister of Police. Dear Minister Mchunu, investigations on matter of crime intelligence in terms of Section 7, subsection 7C of the Intelligence Services Oversight Act 1994, Act 40 of 1994 Oversight Act. Our correspondence dated 24 March 2024 regarding the above subject matter refers.
Just
That date
to, I think
must
it should be
25.
2025, yes. But it's not, you're not the author,
I'm not the
but it
author.
makes sense that it be 2025. Continue.
In said correspondence, we appraised the Minister on the progress made in respect of the investigation and the outstanding interviews with specific officials from Crime Intelligence Division of the South African Police Services, SAPS-CI. We were advised on the 27th of March 2025 from the Chief Financial Officer, CFO of SAPS-CI would not be available for an interview on the scheduled date due to prior planned leave, and would be available on the 8th of April 2025. Based on the foregoing, we are unable to meet our envisaged date of 4 April 2025 to conclude this investigation without the critical contribution of the above-mentioned official.
And who was the official, the CFO, that was being referred to?
It would be Mr. Lushaba.
Where is the rest of the letter?
I have brought the documents.
Chair, the witness brought the document this morning with the report. We still need to discuss with the NPA allowing us to use the report. It's the first time anyone has had sight of the report, and she brought hard copies. She didn't send an electronic version. She had received it via WhatsApp as well. This was just the photograph that she had taken initially to show us that she does have it. But she's brought it this morning with her. We will then deal with the I think there's a page 2 which has the signature and a short note, so we'll deal with it then during the lunch adjournment.
The report is the letter.
We have this is the covering letter, and there is a 77-page report.
I'm asking about the letter. The letter is incomplete.
Yes, there's a second page, so she just took a photo of the first page, but she's brought the covering letter with both pages and the report itself.
Okay.
Yes. We can go to page 601, which is then the WhatsApp where you receive it, and this would have been, let me just get the correct page. It's not 601, it's 612. Just bear with me, 609. 609. Chair.
Ms. Nube, you will guide, because you're dealing with the report, you will guide whether this question can be answered or is subject to you getting approval. My question is, you've looked at the report. What was the complaint that the IGI was investigating? And I'm happy for you not to answer if it falls under you need to get consent from the NPA. Is it one of those?
I think I would rather, once I get consent, then I'd be able to explain. But at this point, because the report and I don't have the authorization from the NDPP, if I mean, reserve that.
All right, that's fine. Thank you. Thanks.
Thank you, Commissioner Baloy. We'll sort that out during the lunch adjournment. The second page of the letter reads paragraph 5. In this regard, it would be appreciated if we could present our report containing findings and recommendations on Thursday, 10 April 2025. 6, thank you for your attention and consideration of our request. Yours sincerely, it's signed by Mr. I. Fadiel, Inspector General of Intelligence. And then it says investigations on matters of crime intelligence, investigation of alleged irregularities pertaining to procurement of buildings, validity of recruitment process, and security clearance of senior member of South African Police Service, crime intelligence SAPS CI. That was the investigation, Chair, but the report hasn't yet been perused until we've dealt with the issues with the NPA. So if we can then go to page 609, this is where you receive, this is after the meeting of 1 September where Mr. Perumal tells you how he got the report. And we can see 2 September, this is from him to you at 1451, IGI report PDF, 77 pages. We can confirm that the covering letter is 2 pages and the report is 75 pages.
Correct.
Okay. Now back to that meeting. He references page 45 to 75, and he must have then had a discussion with you as to what 45 to 75 contains, what it deals with.
It dealt with the appointments and vetting aspects, yeah.
In respect of the matters that IDAC was also investigating?
Portions, yes.
Portions, so more than what IDAC was investigating, or was IDAC investigating more than what the IG was investigating? Or were they identical?
I can't pinpoint exactly how, but I do remember that Advocate Sarunya, myself, and Advocate Schlatzwayo read the report, and Advocate Sarunya also sent an email based on it saying, I read the IGI report and it takes us no further.
And insofar as the IGI report is concerned, we know now that Mr. Perumal gets it through the Office of the Minister.
Correct.
And you say that you know that we're not IDAC is not supposed to get it that way. How were you going to use the report if it was beneficial or if it was corroborative of IDAC's investigation? Was there a discussion about that?
It's the same thing as the email that's a subject heading secret, where somehow, some way, Mr. Perumal got, I think it's General Particular's disciplinary assessment report on all the, so it's the Mokwele and the 6 others. So when he emailed it to us, the subject was secret. And so the discussion stemmed that it was going to be used for intelligence purposes, but prosecutors don't use things for intelligence purposes. And I think that's also what stemmed Advocate Sarunya's email saying it takes this case no further.
But when he was discussing the report, because you hadn't seen it at that stage, but he was discussing it, was Mr. Perumal saying that it is supportive of IDAC's investigation and the charges that you were pursuing against the crime intelligence officials?
His words were, it's golden.
Okay.
So, yeah.
It was?
Was in support of.
Do you know if Advocate Sarunya also got the IG report?
Yeah, what happened was when, because Advocate Sarunya doesn't like WhatsApp, so it was WhatsApp to me and then printed. So we printed 3 copies for the 3 advocates to work off.
Okay, and so after he then perused that, he said it doesn't take the matter any further?
It takes the case no further, yes.
Okay. Then I'd like to move on to...
Maybe before you move off this, you say in the past you have had cooperation with the IGI office in other matters.
Correct.
Ordinarily, what is the process for you to get that cooperation and to get their reports?
It must
for
be
your
finalized.
people. How does it work?
The report must be finalized.
Yes.
And then it must be given to the authority that controls the IGI or requested me, the president, the minister's office or whatever. Okay. But that report is only supposed to be released once it's finalized. Yes. And then there's mutual legal assistance that we would then sit and discuss, okay, portions of this, guys, we're going to have to redact, you can't use it, we cannot disclose it to you. Portions we can disclose in terms of just for you to guide where you might possibly want to go for your investigations, but it would never be the full report. Yes. And it would only be the finalized report.
So just to make sure that I understand, in the normal course, this report that you end up getting by WhatsApp, you say in normal proper course, it would have come from the IGI to whoever is the authority that the IGI reports to, be it the president or the minister responsible for the IGI. And then it would go to IDAC directly or to the Minister of Justice, Minister of Police. I just want to understand how Minister Mkhunu if things were done properly, how he would end up with this report? To your knowledge, from your experience.
From the way, because the only other matter that's getting assistance from IGI is under advocate law. So when I was going, because I was walking in blindly, I had not dealt with the IGI previously. So when I asked for assistance on how it works, it's a confidential document or a top secret document. It also has to be declassified before it comes to us. So this document was not declassified. It's still in its raw confidential or top secret form.
That's contrary to how it's normally done in the normal course. It would have had to be declassified for you to look at it,
Correct.
to be able to work with it.
Correct. And there needs to be, so like I was explaining, in the mutual legal assist, you would then agree, paragraph 4, guys, we're redacting, paragraph 5, you may use for this purposes, I'm not disclosing these witnesses.
Thank you.
Just explain this in your discussion with Mr. Perumal. What did he say you must do with this report? Because he's sharing it with you on WhatsApp. Did he say you must read it and then what? Assist you in your prosecution of the ongoing matters?
Commissioner, the way it was explained to Advocate Sarunya, Advocate Schlatzweiler, and myself, it was after we read it, the advocates will have a better understanding of what we're supposed to prosecute in the Mokwele docket.
I see. But you say this was a draft, it was not final. Or it had not been sent to the relevant people who were supposed to get it, whether they are a minister or a relevant body.
All I know is that the minister sent the reports that IGI refused to give us to Mr. Perumal. And in terms of the Act and the mutual legal assistance that we usually, it's not proper procedure.
Thank you.
And it's being shared on WhatsApp.
Did I hear you to say the minister gave it to somebody who went and delivered it to Mr. Perumal?
Mr. Perumal's words during the meeting on the 1st and then repeated on the 2nd was that the minister made arrangements for someone to fly with the report to meet him in Eastern Cape or East London to hand the report to him.
Okay. Thank you.
Thank you. I now want to deal with the bail amendment and the application, the bail appeal on the
Section
Mokwele
63.
matter. Yes. So when Advocate Sarunya gave evidence, he explained that he was involved in that process. You were also involved in that process. What we want to understand was what was Advocate Johnson's involvement in that process and the decision-making by Advocate Johnson during that process. Now, we know that there was an application by the accused to amend the bail conditions insofar as, particularly the one that we're interested in, is the bail condition that they were not to enter into any crime intelligence offices throughout the country.
Correct.
That formed part of a bail application in terms of Section 63.
Correct.
And you had a discussion with Advocate Johnson about that application?
So Advocate Johnson was on the phone or Teams comms with Mr. Beluchin, Mr. Padiachi, and Mr. Perumal. And I was contacted by Advocate Johnson's PA that I must come in urgently. They were also looking for Advocate Schlatzweiler, but it was lunchtime, and I think I was the only one in the office at the time, of the three of us. So when I got there, I stood at the door of Advocate Johnson's office, and she instructed that we must oppose the Section 63. And that we must start drafting. And then a few minutes, I think it was maybe half an hour later, she sent a WhatsApp to me saying...
Can we go to that WhatsApp?
Yes, please.
Page 610, 610 of file 10, part 2.
Thank you. Brief Peter and tell him what I have requested.
Just wait first.
Sorry.
So it's 6:10, 9 September 2025, the message from Advocate Johnson at 1:11.
So this is after I was called into the office and told. And then Advocate Johnson WhatsApps me, brief Peter and tell him what I have requested. Does he agree? I reply, I will. He has stepped out for lunch as soon as he is back.
Sorry, it's not your fault this time, but could you just move closer to them and raise your voice because there's sound from above. I will. He has stepped out for lunch as soon as he is back.
To which he replied at 13:12, okay. After a conversation with, it was about a 2-hour, maybe an hour and a half conversation between Advocate Hlatshwayo, Advocate Surunya and myself. We even pulled out the CPA commentaries and we were researching this instruction. And so I sent Advocate, so after this discussion, I asked Advocate Surunya whether I must inform Advocate Johnson, and he said yes. And then I sent a message saying, Advocate Johnson, we have discussed the section 63. We do not have legal grounds to justify the application. We have done reading on CPA and commentary based on the current circumstances. Her reply is noted.
When you say we don't have legal grounds to justify the application, do you mean your opposition to the application?
Correct.
Okay. So she says noted, and then what happens thereafter?
On the 11th, my apologies, on the 11th of September, because Advocate Johnson, because Advocate Surunya doesn't have WhatsApp, on the 11th of September, Advocate Johnson sends me a message at 19:18 evening. I want to see you, Peter, and Joy in my office tomorrow at 8:30 a.m. Peter doesn't have WhatsApp, so I can't message him. I reply, evening, Advocate Johnson, noted, I will call him and advise him. She says, thanks.
Then page 611 deals with a different aspect where you're telling her about the Lushaba bail conditions, right? And she's telling you that Advocate Mshololo must go through Peter and all of that.
Correct, yes.
At the bottom of that page 611, she says, why is she asking you? She must ask a client. And then you says, but we will discuss in the morning. This is in the morning because she's asked to meet with you
at 8:30.
Mr. Surunya and Advocate Hlatshwayo in the morning.
Correct.
Then at 612, you can continue there. This is still the evening of the 12th at the top.
Noted, thank you. I have spoken to Advocate Surunya and informed him.
And this is in reference to the Advocate Mshololo, that you say, I've spoken to Advocate Surunya and informed him.
Correct.
Okay. So then on the 13th.
On the 13th at 16:48, Advocate Johnson sends me a message, Droof. I have read the supplementary prepared by Brian. It's very good. I expect all prosecutors to meet tomorrow and make sure everything is sorted and that arguments are ready. Kindly inform Peter and Joy. I know it's Sunday and I will give each of you time off for putting in time tomorrow. I will also try and come to the office to see how things are going. I reply, afternoon, Advocate Johnson, I will inform both and request that I join either via Teams or WhatsApp. I had my mom for the weekend.
Okay, then you say, she says, sorry to hear, let them do a Teams meeting because all three need to be on the same page, please. Thank you.
Correct.
Is this still about the bail or this is Lushaba now at 612?
So the messages that Advocate Johnson was sending were about the Section 63, us opposing the Section 63. But in that time, Advocate Mshololo had contacted me and asked for Mr. Lushaba's bail conditions for the second matter, the Mokwele matter. So, because Advocate Johnson doesn't allow us to speak to the attorneys on these matters without informing her, I had screen grab and sent it to her.
But the meeting that she called for was for the bail amendment application that she wanted to meet with you, the three of you, and you had expressed the view that there was no legal grounds in respect to the application. She then wanted to meet anyway, and at that she wanted, based on the affidavit of Mr. Padiachi, she wanted the prosecution team to oppose the application.
Correct.
Okay, and then did you meet on the 14th, Sunday, the 14th of September?
I joined on Teams, so did Mr. Perumal, Mr. Padiachi, Advocate Surunya, and Advocate Schlatzwayo met at the boardroom in VGM, our head office.
And Advocate Johnson was part of that meeting?
She did not attend.
Okay, so she wanted the three of you to prepare the application or to prepare the opposition to the amendment application.
Correct.
Okay. And you had to do that based on Mr. Padiachi's supplementary.
If I may just explain what was happening at that time. If the commissioners will remember, Chair, the bail application for Mr. Lushaba was postponed to the following week because of the magistrate indicated it was a Schedule 6, and because the affidavit said Schedule 5, there was basically no application before him. So the following week, Advocate Schlatzwayo and myself attended to the bail application of Mr. Lushaba. It was before another magistrate. When Advocate Schlatzwayo read into record all the bail conditions that were imposed on the other 6, the magistrate had said specifically, I am not going to jump onto that boat. In essence, what that magistrate did was suspend the 6 accused prior to the employee even being involved. And so he refused to grant that. And when it was reported to Advocate Johnson and Mr. Perumal and Mr. Padiachi, Advocate Schlatzwayo and I were hauled over the coals because according to them we should have insisted it was. So it was at that point that I spoke up saying, but the magistrate is right. And later on, even with the discussions, I did indicate earlier I was voted off the team because I bear the view that we cannot go and oppose this application. My argument was that the magistrate made the ruling. The state can say that they're leaving it in the hands of the court.
You're saying for the Lushaba bail matter, the second magistrate refused to put the same condition that applied to the other accused the previous week, that they cannot go to the crime intelligence offices.
Correct. And if I may just elaborate on that. When Mr. Lushaba did in fact go back to his office, there was great panic amongst Mr. Perumal, Advocate Johnson, and Mr. Padiachi, to a point where they even wanted me to do a Section 63 application against Mr. Lushaba in the housebreaking matter, and I refused.
So
I said, on what basis? It's a Valeria docket, there's no witnesses from there. So on what basis are you supposed to do a Section 63 to prevent him from going to the office?
I think then the question Advocate Baloyi was asking, this Section 63 that you were referring to was a Section 63 that IDAC wanted to bring. It was not the Section 63 relating to the parties in the earlier Mokwele bail.
With regards to the messages?
Yes.
No, at that point, Advocate Surunya, Advocate Schlatzwayo, and I were not going to oppose the application in terms of Section 63 to relax the bail conditions in terms of Ms. Mokwele, Ms. Ngube, Mr. Khumalo, and Mr. Lekhalakhala. And one other, I can't remember who. And Advocate Johnson had instructed that it must happen. So in that conversation, she wanted me to take the instructions and discuss it with Advocate Serunye. We said there's no basis. 2 days later, we're getting an instruction based on Mr. Padiachi's affidavit, which is very good. We are opposing.
What Commissioner Khumalo wants to clarify is the Lushaba matter. Now you're in Lushaba. This Lushaba that you're talking about, it still relates to the Mukwele matter because
Correct.
his bail was not heard.
Correct.
So you go back another week for now just Lushaba. And that magistrate said, I'm not imposing those conditions.
Correct.
That were imposed on the other 5.
Correct. He in essence said that it's a violation of the employer's right to deal with a disciplinary the way they see fit.
And then you go on to say that following that Lushaba appearance and refusal of the magistrate, General Lushaba went back to the office and there was panic on your people's side, and now you get an instruction to now bring a Section 63 in the laptop matter, in the standalone matter, and that's what you refuse to do.
Correct.
I think that's what Commissioner Khumalo wanted to clarify.
And if you look at 610, that's where you say we do not have legal grounds to justify the application. So it seems like you're not talking about opposition here. You're talking about IDAC bringing the application, and you are saying you don't have legal grounds to bring the application.
It's a possibility that was the conversation there. It is. I'm sorry, I'm trying to juggle 3 years of activities into comprehensive meetings. But I agree with Commissioner that it looks like that on the 9th, the instruction to bring the application on the standalone against Lushaba was the instruction at that point. And we said there was no legal grounds, correct?
So that is why I'm asking the supplementary affidavit prepared by Mr. Padiachi. What was that referring to? That's on 612.
That was in regards to the CI7, the Mukwele, Ngube, Khumalo, Lekhalakhala.
Okay, go to 612. So on 612, when Advocate Johnson says, I have read the supplementary prepared by Brian, it is very good. I expect all the prosecutors to meet tomorrow and make sure everything is sorted and that the arguments are ready. What was this for? Was this for the amendment on the Lushaba matter, or was it to oppose the CI7 application to amend their bail conditions?
This is to oppose.
Was it happening at the same time?
Yes, because Mr. Lushaba went back to work or to the office around that time. So they were trying to use one case and bail conditions in the one case to fix what they considered was an error by the magistrate in the second case.
Okay, yes, it seems that you are correct. Advocate Poe says to me that that was in line with Advocate Serunye's evidence as well. So Advocate Johnson's instruction to you that message was to bring the 63 application in respect of the Lushaba matter, but when she says you must, on the 13th, that she's read the supplementary, that relates to the CI7.
Correct.
Okay. And so you meet and prepare which application then? So what are you preparing on the 14th of September?
On the 14th of September, while the teams was happening, Advocate Serunye was going through Mr. Padiachi's affidavit and asking Mr. Padiachi and Mr. Perumal to explain each paragraph of the affidavit so that he could understand how it was going to be argued. And so that's how 3 hours went by. And then I excused myself at 5.
Okay. Then on page 613, if we can just deal with that on the 14th. So there on the 14th, now this was the day of the meeting, the team's meeting, and can you just read this message and tell us what's going on here? We know that it was a team's meeting.
Okay, but the last portion,
It has been redacted.
It has been
yes.
redacted. Okay.
Yes.
Thank you. Okay, so on the 14th, Advocate Johnson sends me a message at 14:55. Drew, sorry to be a pain in the butt. Parliament has summoned the NDPP and Madam expects me to go with. I need the bail conditions in writing of both matters. Can I please get copies of both charge sheets with bail conditions before close of business tomorrow? Can you email or WhatsApp to me, whichever is convenient? I hope Mom is doing a bit better. I reply, afternoon, Advocate Johnson. It's never a problem. I will forward leg 1 now and ask Joy to send leg 2 immediately. We are on Teams.
So you were still in that meeting?
Correct.
Okay. And so we'll speak, I am sitting and preparing the prep exco tomorrow on what we have to respond to. Now, this is while you're having the meeting and you're discussing the various applications and opposition to the applications. And what was Advocate Johnson requiring the bail conditions for purposes of the NDPP's appearance at Parliament? This was, I assume, at the ad hoc committee.
Looking at the date, yes, correct.
Okay.
My understanding is that there were questions in relation to the Mokwele matter at the ad hoc, but they wanted both charge sheets and bail conditions.
Okay, so, and she was just being asked by the NDPP to assist with that?
Correct.
Was she not aware of what the bail conditions were, or was she looking for a document that had it? Was that the only thing?
No,
She knew
Advocate
what it
Johnson was well aware of bail conditions on both. That's why she says, can I get copies of both charge sheets with bail conditions before close of business tomorrow? So it would have been the J15, the annexes to the charges, and the appearance sheets and the notes of the magistrates that she was looking for.
Okay. Then just one last issue before we get to the Medicare 24 is there is a you'll recall that when you gave evidence the first time and you dealt with the missing section 27 and the email that you sent on the 9th of October 2025 setting out what had happened, that Advocate Johnson had given you the affidavit, you brought it back to her office, and you said that Advocate Johnson responded to your email via WhatsApp, and if she disagreed with your account of what happened, she would have said so. At the time, we didn't have that WhatsApp. We now do have it, and just for it to be placed on record at page 614, if you can read that into the record, just remembering that this is in response to your email of 9 October 2025.
Thank you. At 15:04, Advocate Johnson sends me a WhatsApp saying, Drew, I saw your email and I will look in my office tomorrow. I might have made a mistake and told her that Chief called you today. When I spoke to the Chief, he was referring to you having the section 27 initially, and that Tsepo spoke to you today. It was my mistake. Chief didn't say so. I reply, noted, Advocate Johnson. Thank you.
Thank you. And did Advocate Johnson get back to you as to whether she found the section 27 in her office?
No, never did.
Sorry. And at this point, you are discussing which section 27? Is it the one that was presented before us or the one that references the PKTT complaints and others?
In the email and in this, there was, as I stated, my interpretation of why the commissioners and the chair ended up with this is that they were trying to make sure that the original, there was no copies of the original to show that there was PKTT. So they were alleging that I said I had misplaced it, which is why I responded in email in that manner. And Advocate Johnson replies in WhatsApp. And then when I see the 27 referral flighted here, in my head, I put two and two together as to why they were trying to scapegoat me with the 27 missing.
So the 27 referred to in this WhatsApp message, where she says, I made a mistake, she's referring to the one that you saw and had to give back to her?
Correct.
Okay, thank you.
Thank you, Commissioner Baloy. Then it really is the last topic on this aspect. In your notes on file 11, page 59, because we are dealing with the topics and not going chronologically, I don't want to miss out on this point because it does fall under the Mokwele matter, even though the timeline is June 2025 and we deal mainly in June 2025 with the Medicare 24 issue. This is your notes regarding a meeting on the 10th of June 2025, where you say it was the ID was present: Joy, Sesoko, Charles, Pat, Brian, Dylan, and you. And you were discussing the project operation or project diversion. There is in the corner, in a block on the right-hand side, a reference to somebody's name. You'll tell us who that person is, and in charge of vetting. I just want you to address the commissioners on that note.
This is a meeting that's called by the ID to discuss the takedown. Before I get to that block, can I just, the reason I want to just discuss this portion is it will also explain how this block happened. So, Advocate Johnson, who is the head of office, who's not on the ground doing investigations, is now informing the prosecutors and the investigators where accused number 3, Mr. Hudson, must be picked up from. Meaning when the team goes to arrest him, they must arrest him from his home because he works at a safe house. These are now the instructions from Advocate Johnson.
This is where you say, what is that word where you say something for Thursday?
Aim for Thursday.
Aim for Thursday. So you're aiming for J50 Thursday?
Correct.
And she's telling you, she's now setting out what is to happen to the accused when the arrests are executed.
Correct,
okay.
Because at that point, all the arrests that I had been involved in IDAC, we would phone the suspect or the accused person, and we would ask either for the legal representative's number, or we would speak directly to them. Being the lead investigator would do that. It's called call a friend. That's what we call it.
It's called?
Call a friend. So we would say call a friend. We'd call them and inform them, listen, please hand yourself over at the police station at 6 o'clock on Friday morning, so that you are processed and taken to court. We are not opposing bail. Please ensure that you have your legal representation present so that the bail can proceed. That is how, in my experience in the past 4 years, almost 4 years, that is how it's been done with the investigators. Here, they are arresting on the Thursday.
And ordinarily, has the ID been involved in that call a friend decision? When you get to that point, does she give instructions? Now you must go arrest and call them, call a friend and tell them to present?
If I may just give an example. So the ID chooses which project she gets involved in when it comes down to takedown. So in the 2023 27 referral, when everything was complete and we were ready now to enroll the matter. Like I said, I had a very strong deputy director, but even he couldn't stand up to Advocate Johnson. And there was plans to go and arrest the suspect and drive the suspect for 6 hours so that they can appear in Pretoria. And I'm saying to them that this person is an elderly person with comorbidities. It can never happen that way. You cannot put them in the back of the car to drive them, especially for something that happened in 2014. So eventually, the deputy director and I got very frustrated, and because they wanted to make a spectacle of the arrests. They wanted flash and lights of cameras, and so eventually the deputy director and myself went to Mr. Sesoko, and we said, please go and speak to Advocate Johnson on our behalf, because this arrest cannot take place this way. So here, there was no, I think from the evidence the Commission has heard thus far, no matter what was said during this project, what Advocate Johnson and what Mr. Perumal wanted was done. So there was no reasoning. So they were planning to arrest on Thursday to appear on the Friday. Advocate Johnson was asking where Lushaba was going to be picked up from. Then Advocate Johnson was advising that Hudson must be picked up and taken to the station for processing from his home because he works at a safe house, and that they had to figure out where Eugene was because he's traveling a lot and he's medically boarded off or something, so he's not permanently within crime intelligence anymore.
This list is the Lushaba matter?
Correct.
Okay.
Now going to the block that I had explained to Advocate Ngube. So we in Advocate Johnson's office, and we're sitting at the boardroom table and we're discussing. Advocate Johnson is now giving instructions about what must happen in the third week, because remember, every second week she wanted arrests. Advocate Johnson looks at me and she says, Drew, you'll be embarrassed to be Indian. So I was taken aback because I was busy taking notes, and I didn't know that they were talking about the person who's acting as in Mr. Khan's place. It's a Miss Krishna Dutt.
General Khan's position, yes.
Correct. It's a Miss Krishna Dutt.
Brigadier Krishna Dutt.
Thank you. So Advocate Johnson says, Drew, you'll be embarrassed to be Indian. The way she walks around talking to the staff, you'll be embarrassed. And then I'm told that I must, when I'm getting to the point of enroll or looking at the evidence for the vetting, because Brigadier Krishna Dutt is acting as the head of the vetting department at the moment, I must look if there's evidence to charge Krishna Dutt.
As part of CI7 in the Mukwele matter?
Either CI7 or the other two.
Okay, so one of the vetting matters.
That is why it's there in that block the way it is.
And who is Brigadier Krishna Dutt?
So from that conversation in Advocate Johnson's office, Advocate Johnson then said, when she was explaining how Brigadier Krishna Dutt speaks to this staff and why I'd be embarrassed and all of that, she indicated Junaid is reporting to her. So at that time, I already knew that Junaid is Mr. Johnson, Advocate Johnson's husband.
And the issue with Brigadier Krishna Dutt is that she was promoted to brigadier before Brigadier Johnson?
I came to learn that after, when I was inquiring as to what exactly is up with, because it's the first time I'm hearing the name. We now already almost 6 months into the investigation. It's not on the 2830, and I'm being told to look for. But the manner in which it was explained in the office about being embarrassed and the way the brigadier speaks to her staff and the screaming, etc.
And Brigadier Krishnadat hadn't come up in any of the previous meetings, any documentation regarding any of the matters at that stage?
No, in fact, Mr. Perumal called me later that evening after this meeting, or maybe later that week, but after this meeting. And he said to me, "Hey, Dee, I looked, but I can't find any evidence against Krishnadat."
And did Advocate Johnson give an indication as to where she was getting this information? Was it pillow talk or was it coming from General Khan?
I cannot answer that. I had my own ideas because of, my own assumptions because of the way the investigation was being done. And the fact that in every single meeting, Advocate Johnson would refer to Mr. Khan. Either Mr. Khan messaged or
General Khan, you
General Khan. Or that Mr. Perumal had spoken to General Khan.
Okay. Thank you for indulging me on those matters. Yes.
Are you going to be coming back to this page 59?
No, Commissioner Balu, I have strict instructions to move on to the next topic, so you may go ahead.
Okay. Still at that page 59, just to complete and make sure that I don't draw my own conclusions, what it means. So you have, in the next subheading, you have third week off, and you have names, you have Ntsiya might come in after Ngube, no Ntsiya Madondo Mkwele. Was this the next set of people you were required to arrest?
Commissioner Baloy, in this paragraph, I'm told that there's a member of crime intelligence called Ntsiya who might be willing to talk.
I see.
And this is coming from Advocate Johnson.
Okay. And then the next one, that's really what I'm interested in, which you have an asterisk next to it. You have J50, tell somebody that I can read, equals message NDPP, reply, and then go. What is this note about?
Okay, Advocate Johnson had indicated that this is how she expected the arrest to happen. Once the J50s were authorized, I was to inform her. From there, she would then message the NDPP that there's a takedown from IDAC happening. And then once the NDPP replied, all the teams that were set to do the arrests were then to go.
Okay.
And so that's how the...
And NDPP being Advocate Shamila Batoye at this stage?
Correct, Advocate Batoye.
And was that kind of report notifying the NDPP, was that standard practice? Is that how it worked? When you do takedowns, did you forewarn the National Directorate of Public Prosecutions?
I only know of 2 instances. Apologize. I know of 2 instances. The 2023-27 and this one.
In the others, I mean, you know more than 3 matters since you've been there. Are you saying in other matters there's never been a reporting to the NDPP?
Not to my knowledge.
Okay, thank you. Thanks, Ms. Nobi.
And just insofar as the arrests, the execution of the arrests were concerned, what was Mr. Sissoko's role meant to be in that process?
There was an email the week before with regards to Advocate Johnson instructing Mr. Sissoko with regards to how to control the arrests and when and how. So when
That page 410, can we just maybe, if you can give your evidence with reference to page 410, which is file 10, part 2. Part 1. Part 1.
410.
Yes. Just let me know once you have it.
Yes, that's correct. On the 4th of June.
Okay, so this is before this meeting of 10 June.
Correct, yes.
Okay. And it says, it's from Advocate Johnson. Sissoko, I asked Dylan to let me know when they will arrest as I need to inform the NDPP. He indicated that the main accused is on leave, etc., and they might push for this afternoon. I let him know that I don't agree. I cannot tell the NDPP today that we are arresting today. What will our urgency be based on? In addition, the DPP is not a rubber stamp and should be given an opportunity to read the papers. I suggest we wait for 2 weeks when the main accused is back at work and then proceed. I'm also aware that accused 4 is not in Gauteng. The team must use the next 2 weeks to determine exactly where all the accused are. When we do arrest, we should be able to pick them up at one go.
Correct.
Okay.
So on the day that on the 12th of June, when the arrests of 2 accused were effected and the other 2 handed themselves over on the morning of the 13th. When I left the boardroom, Mr. Sissoko was in the boardroom with, if I'm not mistaken, there were 4 teams of 4 investigators that was set to go and arrest. So when I left the boardroom, it was the team, Mr. Perumal, Mr. Padiachi, and Mr. Sissoko.
Yeah, we've had Mr. Sissoko, who largely portrayed his position or participation in these matters as passive because he was sidelined and he didn't really become involved and he kept his head down. That's some of his evidence. In the end, documents were produced, email exchanges that show him addressed. How would you describe his involvement with these matters? I mean, to state the obvious, at 410, it suggests that he was involved. That's why he's getting this kind of report from the ID. But I would like to hear in your own words how you describe his involvement in these matters against crime intelligence.
Advocate Johnson would involve Mr. Sissoko when she felt like it. And then in those meetings, he would be, she would say he's the go-to person for this, as I will illustrate a bit later. But in essence, he was not party. He was, can I say 1 foot in, 1 foot out? So he was involved, but not in the decision making. He was involved in a lot of the meetings. He was involved in a lot of the complaints and fights. And with regards to just putting his head down and turning the other way, just to give you an example, Mr. Sissoko spoke about a meeting where he facilitated coercion amongst myself and Mr. Perumal, and In that meeting, Mr. Padiachi leaned over the boardroom table, screaming at me with his finger in my face. And I mean literally, if I moved, he probably would have hit me, or if he could get any closer, he would have hit me that day. And no one said anything, and Mr. Sissoko was chairing the meeting. I was called in later by Mr. Sissoko to say, the way he speaks to you, Drew, no, I'm going to call him and speak to him, but why didn't you say anything when he was doing it? And then I find out later on that incident is not even reported to Advocate Johnson by Mr. Sissoko, who was supposed to take a full report, and it's reported that we have now found common ground to work together. But we hadn't, because Advocate Serenia told the commissioners in chair that I wasn't even talking to Mr. Padiachi after that.
Let me ask differently. Mr. Sissoko is head of investigations. Maybe let me say that in my engagement with him, I characterize the quality of investigations as poor, as you complain, that you looked at what was being brought to you. And the question to him was, where was the head of investigations when you look at these documents from your people, these reports? So my question is to try and understand whether in meetings where you were present, did he engage about the quality of information that is being put to the prosecutors, on the basis of which you are making recommendations and decisions, on the basis of which the investigating director is making decisions or required to make decisions? What was his participation as head of investigations in that?
So I'll give you an example of what happened on the 12th of May. Mr. Sissoko said, because there's this dispute now between the prosecutor saying there's no case and the investigator saying that the prosecutor doesn't understand the case, both sides should do a report, as I've explained, with the links and how it would link to the offenses, etc. It was agreed that would be done. And the very next day, Mr. Perumal is saying, I'm not going to do it because those things come out it would have been used in this commission, those things come out as material later. And Mr. Sissoko was not able to enforce it because Advocate Johnson had sided with Mr. Perumal.
Thank you.
Okay. Can I just take you to the topic of General Khan's statement in the Lushaba matter, the A28, and what happened there and the issue that you raised? For that, can we go to page 586 of 10 part 2, file 10 part 2. And we'll start at the bottom of the page, where Mr. Padiachi on the 28th of January 2026 sends an email to you and Mr. Perumal with the subject A28 affidavit, Major General F. Khan. Hi Drew, please find copy of A28 affidavit of Major General Khan. Why was he sending you this email, the affidavit?
There was a meeting. Because the investigators were not gelling with the prosecutors, Advocate Johnson instructed that we were supposed to meet once a week. Even though the matters were already in court, we were supposed to meet once a week and discuss. So on that particular day, so we were supposed to be in court that Thursday or Friday for the Leg 1 Lushaba matter. And in that meeting, I discovered that there's a statement that's commissioned in September 2025. I've not been provided. A defense has not been provided with the statement, and I've already replied to request for further particulars on 3 of the 4 accused. So I was highly annoyed.
Sorry, I just wanted to know, he was sending you the affidavit following a meeting that was held?
Correct.
Where they said that there was the statement?
Because we were going through the annexure or the aids, And I said, but where does A28 come from? Because, I'm sorry, I don't have an A28, and that's how it came about.
Okay, so he sends it to you, and then you respond on the top of page 586. And if you can perhaps just read to us what your response is, because I think it's important to place in context that this is now the affidavit of Major General Khan, which has not been disclosed to the accused.
Correct.
After you had made discovery.
Correct. Good day, Advocate Surunya, Mr. Sissoko and team. I have discussed this with DDPP Surunya. It is distressing that we are being made aware of and receiving an affidavit that was commissioned in September 2025, only today, and it creates problems at court. If the prosecutors were made aware of it, we could have disclosed it in October 2025 court appearance, or even in December 2025 when we replied to the request for further particulars. We are now going to give disclosure on the day we receive representations made to NDPP. This in itself is going to be a problem, as they are now going to say we withheld a statement, did not make a full disclosure, and they need to consult and possibly redraft the representations. Inasmuch as this is a prosecution-led environment, we need to work as a team.
Can you just move closer to the microphone again?
We need to work as a team. And that means prosecutors must be made aware of these developments. I am now faced with explaining why an affidavit commissioned in September 2025 is being disclosed in January 2026 at court tomorrow. And thus, we will be blamed for delaying the matter in court tomorrow.
Then there's a response from Mr. Pariachi on page 585 at the top of page 585, where he says, it is for this very reason that I've requested meetings regularly, and he says, I was under the impression that this affidavit was handed to Advocate Drew and will verify with team members whether this was done. There are many issues with regards to this matter, from the bail applications and short notices. We were in the boardroom when this affidavit was discussed. Why is it now being ventilated in this manner? I'm under the impression that we work as a team. Chief, may we have a meeting tomorrow after court? I'm interested more in the response that comes from Mr. Perumal on 584, at the bottom of 584.
If I may just have one.
Yes.
Thank you.
Mr. Perumal then responds also on the same day, and he says, good afternoon, Advocate Sarunia and all. Can you just read that?
I am in PMB at DPP, Advocate Harris's office. I will be back tonight. I am also very tired of hearing about prosecution-led investigations when we are not following PLI to the letter.
He probably means to the letter. You're not following prosecution-led investigations to the letter.
Correct. I am also confused that since September 2025, Advocate Drew has not seen the affidavit. How did this happen? I recall that Charles went to get it from him after a full discussion by the team, excuse me, that such should be obtained. Let's get together tomorrow after court, please. Pat and Charles are in Kimberley. Pat, please ask Brig Tate to arrange for a quiet spot at the provincial office so that the two of you can link up with us for the meeting. Tsepo, kindly confirm I think it's coordination with them on the time so that they plan and make time to join us. Regards, Chief Perumal.
And then you respond to that at the top to say that Charles provided you with two handwritten uncommissioned statements of A5 and his crew. You were not furnished with the A28.
Correct.
Okay. So at that stage, none of the prosecutors had seen the A28?
Correct.
Okay. Was this the only affidavit, only General Khan's affidavit that had not been disclosed to the defense? Do you know?
Not long after I sent this, what was called a very snappy email, I was removed.
Yes, there is another email that I just want to deal with regarding the representations to the NDPP from Advocate Johnson on the Lushaba matter. And I just want to understand why there was a change in view, because it seems to me Advocate Johnson is saying that because there's a new NDPP coming in, she doesn't want to confuse matters about where representations must go to by accused persons. But I just want you to deal with it. It's at page 588 of the same bundle. And you'll just have to explain this email from Advocate Johnson. It's a response to you regarding what happened at court, and then you say to Advocate Johnson that you have told the accused representative in the Lushaba matter they intend making representations, and you said to them they'll make the representations to the NDPP, right? Advocate Johnson is upset by that.
So there was a conversation between myself and Mr. Lushaba and Mr. Makhashwa's advocate. He indicated that he intended on making representations about the matter to the NDPP. And that he did indicate that part of it was a complaint against Advocate Johnson. We then agreed that we'll postpone the matter for outcomes of representations to the NDPP. This did not sit well with Advocate Johnson, Mr. Perumal, and Mr. Padiachi, but also it became clearer later on that this became a bigger issue than it needed to be, because they needed to find a way to remove me. But Advocate Johnson indicates that representations come to IDAC, to my office, gets a copy immediately. You and the team draft a response for the ID within 2 weeks of receipt, submit that to the ID's office for perusal and engagement from the team. Response must be sent to defense no later than the last day of February 2026. I then informed, despite the fact that I had communicated with the advocate previously, I foresaw where this was going.
Well, can I just ask you about the line above the red writing where Advocate Johnson says, correct this today as we have a new NDPP starting on Monday, and I don't want confusion on what is going there, like we don't know what we are doing. Is your understanding that representations by accused persons are made to IDAC or to the NDPP?
Sometimes representations come to IDAC, sometimes they go to the NDPP, but in the normal course, so if you have to look at the regional court structure, representations would go to the SPP. And if the accused or his defense is unhappy with the reply from the SPP, it would go to the chief prosecutor. And then if that is a problem then, or a disagreement, it would go to the DPP of that jurisdiction. Here we have the ID who is making the decisions and authorizing the investigations and the prosecution. So my understanding would be that it would, in line of that, in terms of the policy of our, it should go to the NDPP. But more specifically so because the advocate had clearly informed me that his clients had instructed that they were questioning Advocate Johnson's involvement.
Page 592 of the bundle. This is, you send a letter then to an email to General Lushaba's legal representative saying, after having spoken to my senior, representations must go to Advocate Johnson. That is on page 593.
Correct.
You say, good day, sir. We note that you intend to make representations to the NDPP. However, upon consultation with my senior, please note the processes of representations. It must be sent to IDAC head, Advocate Johnson. Should it be refused or your client be unhappy with the outcome, representations may then be made to the NDPP. Trust you find in order. They respond and say, you can start from firstly.
Firstly, IDAC is not party to the court proceedings. The matter is between our client and the National Prosecuting Authority, which has prosecuted charges against our clients and not IDAC. It is therefore the National Prosecuting Authority that must decide on the future of the court matters. Secondly, the head of IDAC has commented on the evidence that the National Prosecuting Authority intends to present against our clients during trial proceedings, and in the process contradicted some pieces of evidence that was disclosed to the defense. This is also a point of contention in our representations. It is for this reason that in our understanding of conflict of interest, even if the process directed that representations be addressed to the head of IDAC, that such would not be an appropriate action.
The cutoff, we hope that you will find the above in good order. And what comments were these by Advocate Johnson? Because they're referring to, this is January 2026. Do you know what, was it the ad hoc committee?
It was evidence at the ad hoc committee. I'm unsure of what the averments were. I do remember reading them in the representations, but I also am not allowed to make those available.
Okay. Chair, that concludes this topic unless the commissioners have anything for the witness on the Mokwele matter. I want to move on to Medicare 24 after lunch. But there may be aspects of the Mokwele matter that may arise during the Medicare 24 matter anyway, because of the timeline, there's an overlap. So Commissioner Baloyi doesn't have to stress that I'm prohibiting her from dealing with the Mokwele matter. There will be in the notes reference to it, but my main focus is going to be on Medicare 24.
Let's adjourn and resume at 2 p.m.
aspect, I promise, before we go to Medicare 24, that I need to cover with you, and it's on page 422 of file 10, part 2. Now, you will recall when you gave evidence, you spoke about a device or a memory stick with a whole lot of information regarding, amongst others, Operation Diversion, which is information that was in the possession of Mr. Pariachi.
Correct.
And some of the documents that you've provided the commission was on that stick, which you understood to be a stick that was Mr. Pariachi's information.
Correct.
His information. One of the documents that you found on there was an unsigned affidavit, or a document that appears to be what would have been a affidavit by Mr. Perumal regarding the Nkabinde issue.
Yes.
And I recall your evidence being that you had seen this affidavit at some stage, and it contradicted, although it's not signed, it contradicted Advocate Johnson's version regarding the call with Mr. Nkabinde, where Advocate Johnson told you that she had received a call from Mr. Nkabinde, but the draft affidavit of Mr. Perumal showed that Advocate Johnson was the one that called Mr. Nkabinde.
And put him on speaker, correct?
And put it on speaker.
Yes.
I just want to deal with that affidavit, and again, just prefacing it by saying that it is an unsigned document which you found on his, and when we look at the document properties, which will be provided, shows that the author is Mr. Dylan Perumal.
Correct.
And if we could just deal with a few paragraphs of that statement. The first is paragraph 2 on page 422, where he says, on 22nd January 2025 at about 12 o'clock, a confidential meeting was convened by the investigating director, Advocate Johnson. The meeting was attended by Mr. Sosoko, Advocate Ramsamy, senior investigators, Pariachi, Rapesu, and I. This is now that meeting that we've dealt with, right?
The first meeting with the presentation, correct?
Yes. He then says, during the ensuing meeting, Mr. Sesoko informed the ID that criminal investigations were conducted against Mr. Cedric Nkabinde while he and SI Rapesu, senior investigator Rapesu, were based in the IPID. Mr. Sesoko also advised the ID that SI Rapesu has evidence in that regard, adding that Mr. Nkabinde was declared to be an untruthful witness in a court proceeding. If we can just pause there, what I noticed is that he doesn't deal with how it came about that Mr. Nkabinde was discussed, became a topic of discussion. You say that it was the ID, Advocate Johnson, who initiated that discussion because of an encounter that she had a day or two prior with Mr. Nkabinde while she was waiting for the minister at his residence for a meeting.
Correct. As per my 1st April 2025 affidavit, I set out that after the presentation, Advocate Johnson had indicated that she had had a meeting with the minister at his residence the evening before, and that she was left alone with Mr. Nkabinde for an extended period of time. And he gave her the heebie-jeebies, and that's how the conversation about Mr. Nkabinde and the investigation started. With regards to this paragraph, the investigation relating to Mr. Nkabinde, those two dockets, sorry, are not held by Mr. Rapesu, nor is he part of that investigation. The one docket is in court for trial in Palm Ridge. He is an investigator formerly of IPID, Mr. Timani Benang, and the other investigation is one of Mr. Lt-Gen,
yes,
which is in the High Court, yes.
Yes. And so there's no explanation, like I said, as to how the topic came about, and also how Mr. Sissoko and Mr. Rapesu actually then volunteered this information that they had on Mr. Nkabinde. Importantly, at 2.2, it stated, the ID then directed that SI Padiachi should conduct an investigation in relation to the allegations made involving Mr. Nkabinde. Now, you put it a bit softer than that. You said it was more just gathering facts and that the ID was doing at that stage. But he seems to already say that at that stage, or would it have been in a separate meeting that the ID then directed Mr. Padiachi to conduct an investigation?
As per the WhatsApps that was previously displayed, as well as the affidavit, my affidavit from the 1st of April, it was when Advocate Johnson had required or sent me a message saying that she had just seen the minister and that we need to move ASAP on the Nkabinde thing. It was at that point that Advocate Johnson, in that meeting, it was only myself, Advocate Johnson, Mr. Perumal, and Mr. Sissoko.
This is now not the meeting of 22 January. This is another meeting,
It's
the 23 January.
23 January.
Yes.
23 January, according to the WhatsApps. In that meeting, Mr. Perumal indicated that Mr. Beluchin can continue with the investigation on Mr. Nkabinde. And then the other investigation was with Mr. Binang at the time. So it was a discussion about that. And Mr. Sissoko said that he doesn't think that anyone from IPID or Mr. Perumal's team must actually continue with the investigation, that a neutral IDAC investigator must deal with the investigation into Mr. Nkabinde. And it was at that point that Advocate Johnson said, Mr. Padiachi will do the investigation.
Then at 423 paragraph 3, it stated, on the morning of 30 January 2025, SI Padiachi and I held a meeting with the ID with regard to another investigation. The ID during this meeting informed us that Mr. Nkabinde had tried to contact her the previous evening while she was at religious prayers, and she was not in a position at the time to take his calls. She explained that she had sent him text messages in that regard. Mr. Nkabinde had also tried calling on the morning of the 30th of January 2025. Now, were you aware of this?
So the version that was given to me by Advocate Johnson is that Mr. Nkabinde did try to call her the night before. She couldn't answer because she was at the temple. However, by chance, Mr. Nkabinde called while Mr. Perumal and Mr. Padiachi were in her office. And so she answered and she put him on speaker. And in fact, in that meeting, she said, you know me, Drew, you know, I don't even take calls and I don't even put it on loudspeaker. But by chance on that day, by God's grace, I put it on speaker. And so that's how she explained it to me on the 30th.
Okay, and at 3.1, he says, I then informed the ID that Mr. Nkabinde contacted me the previous evening to inquire on how investigations were progressing regarding SAPS, crime intelligence matters. I advised him that we were making steady progress and our conversation ended there. Mr. Nkabinde had been assisting in the investigation purely from an intelligence and information perspective in a bid to address the alleged criminality within the crime intelligence division of the SAPS. Were you aware that Mr. Nkabinde was a source of intelligence for Mr. Perumal regarding the investigations, crime intelligence investigations?
No, until I saw this paragraph 3.1 a couple of weeks ago, I did not know Mr. Nkabinde. Also, when I read it, I was trying to figure out how a chief of staff would be a source of information, because that's an informant.
At this stage, you were, however, aware that from the forklift witness that the office of the minister had arranged for the witness to go to the Eastern Cape, right?
Correct. And in
Yes.
that consultation that took place on the 20th in the evening with that witness, where a day after Mr. Perumal said he didn't want the name of Nkabinde mentioned in front of Mr. Rapesu, that witness said that the arrangements were made by Mr. Nkabinde.
By the office of the minister.
By the minister, yes.
Yes, but you didn't know that Mr. Nkabinde was offering intelligence information,
No,
or what that entailed?
No.
Okay.
not at all.
At 3.2, he says the ID then contacted Mr. Nkabinde and placed the cellular phone on speaker so that SI Pariachi and I could listen to the conversation. Mr. Nkabinde informed the ID that he was informed by one of your guys that an investigation had been initiated within the IDAC, instigated and initiated by Mr. Sesoko and others against him, and the person leading the investigation was a Brian Pariachi. He indicated that he was also informed that his banking records were going to be scrutinized from around 2018. And then on the next page, the ID inquired from him as to who gave him this information, to which he replied that he was informed of this by Mansa Rapesu. Now, according to you, Mr. Rapesu wasn't aware of an investigation.
He was not, except for the meeting on the 22nd of January, and where he was asked, so his involvement in this whole Nkabinde thing ended on the 22nd of January, where he forwarded the transcripts of the court proceedings of Mr. Nkabinde to myself and to the remainder of the team. After that, all other meetings, as per my affidavit, Mr. Rapesu was not involved. Excuse me.
Okay. You'll just let me know if you need a break.
I will. Thank you so much.
Okay. And then, so that is just to place in context the evidence that you gave last week about a draft affidavit that you found that had that contradicted, where Mr. Perumal contradicted what Advocate Johnson had told you about the call with Mr. Nkabinde.
Correct.
Okay. And then if we can go to page 426 of the same bundle. And this is just on the housebreaking docket.
It's an email I sent on the 28th of March.
The email is on the 2nd of April, but you want to explain what happened on the 28th of March?
On the 28th of March 2025, Mr. Perumal contacted me saying that, I'm not allowed to swear, saying that Rapesu did nothing on the housebreaking, and they now have to start from scratch, and ID's plan to put the Lushaba matter on the roll first can't happen now because Rapesu did nothing, etc., etc. And so I said, no, but that doesn't make sense, because I was even taking photos of the affidavits Rapesu obtained and sending them to Advocate Johnson. So on the in between the, should I just read the email now?
Well, I just want to clarify. So you referred to, in that email, to the investigator's report, which you attach, which is Mr. Rapesu's report on the housebreaking matter.
On all the work that he had done, what he had discovered, who he had spoken to.
Which you gave evidence on the last time.
Yes.
And then the telecoms with the chief on Friday, the 28th of March, 2025. Earlier on, you said this could have been the conversation where he mentioned the issue about perjury and the National Commissioner.
That's why I'm convinced, because the conversation was quite lengthy, that it would have been around the 28th of March. And prior to that, the communication was very strained and sporadic. So that's why I indicated earlier, it most probably was the 28th of March 2025 where the perjury issue was discussed again with me.
Okay. Then if you can then just read what you say from I was concerned.
I was concerned when Chief informed me that he did not receive the file containing the statements obtained and the diary entries made by Mansa. on the housebreaking docket, as I had previously perused same and had taken pictures of one of the statements and sent same to ID via WhatsApp, and indicated that I was so pleased as I required 2 more statements before I could draft a presentation for enrollment on the matter. On Monday, 31st March 2025, I went to Mr. Sissoko's office and made inquiries. Zandile, being Mr. Sissoko's PA, was asked to open the locked cabinet. In the 3rd drawer, Zandile found the 2 files, and in those files were the original affidavits and the cell phone records as listed in the report attached. The files are still in Mr. Sissoko's office. Kind regards.
Now, just tell us about these files. Why were they locked up?
On the 10th of February, when Mr. Rapesu was given his letter, he was asked to hand everything, his laptop, his whatever was IDAC issued, and any files and dockets. In fact, he was asked to hand over everything, even the dockets for other related or other matters that are not related to the crime intelligence. So my understanding is that he had just given everything to Mr. Sissoko, and it was locked in Mr. Sissoko's cabinet in his office.
Okay. And so you found it?
Yes, it was found. It had an index, it had his full diary entries of everything that he had done, or all the meetings, etc. It had the cell phone records that were obtained from the detective commander on the 38 Valeria 38 CAS docket. So I did this so that they can go and collect it.
What was your understanding of why the chief was now saying that Mr. Rapesu hadn't done anything on this matter?
It was twofold. The first is that Mr. Perumal wanted to enroll the Masiamula Khumalo matter first. And then the second one is that he was in the process of painting a very bad picture of Mr. Rapesu throughout the office.
Okay. Thank you. Now we can...
Before you do that, the Masemula Khumalo matter, was any work done? I mean, you are at a point now, you're speaking about enrollment. What preceded that before you get to this point where Mr. Perumal wants to enroll the matter or is disappointed that he's unable to enroll it? Has any investigation, any work being done about it?
Commissioner Beloy, I'm getting there. It's on page 21 of my affidavit.
I'm going to get there. Yes. All right, we'll park it. And then an unrelated question. This is about representations to the NDPP, and now you have the ID saying representations in this case. In the, I think, Lushaba matter must come to her. What is in place? This is, I've had a quick look at the legislation. I don't see anything, I may have missed it, which speaks to representations and who has the power to make those decisions and the process for it. Is this contained in a policy, and what is the prevailing position? What is the position in fact?
The policy, the prosecution directives policy manual doesn't specifically deal with IDAC. IDAC has not yet been included in those directives. So that is why I was explaining from a regional court perspective. And when the advocate indicated that there were concerns about Advocate Johnson, I had agreed that the representations would go to NDPP, and we would postpone for the NDPP's decision. Advocate Johnson had a problem with that in the sense that she felt that on the arrival of the new NDPP, it can't be representations on this matter in the first month.
So what she directed, or what she was upset about and directing should happen here, is not what is contained in whatever policy you have. As matters stand, representations go to prosecutors. You've said SPP, the DPP, and then ultimately the NDPP. There's no provision for IDAC.
It has not been done yet.
Yeah. So when she says they must come to her, it's outside of the applicable policy because there's nothing that empowers her to take that kind of position.
Correct.
Okay, thank you.
Before you go to the Medicare 24 issue, can you please go to 539 of this file? I'm just trying to get up to speed as regards what is leg 1, leg 2, leg 3, leg 4 of project diversion.
I'm getting to that. That's on page 21.
Yes, it's still coming.
It's still coming.
So just up to here, which one is leg 1, which one is leg 2, which one is leg 3? And then the one you are coming to, you can deal with it as part of your evidence.
So I'm going to just 539 is leg 4.
Oh, it's not leg 3, it's leg 4.
It's leg 4. The second memo of this very nature marked or dated the 2nd of July, 2025, is leg 3. So this one is the Madondo Khumalo.
So can you
it's
then,
the other way around.
Is it the other way around?
Can you then do this for us without detail? Just in that order, which one was leg 1, which one was leg 2, which one was leg 3? And then I think you can pause there because Advocate Ngube is moving to leg 4 next. Or is it leg 3?
No, so Medicare wasn't part of Operation Diversion.
Was not part of
Yes,
diversion.
but in the sequence of events, that's why I said there will still be stuff about crime intelligence, not necessarily the Mokwele matter, but other aspects of crime intelligence, and these are the two.
All right.
Related to General Masemola and General Khumalo.
Let me tell you what I have on my list and could be mixed up. I have the properties case, I have the Mokwele case, I have the vetting case, and then I have the Lushaba matter. Those were all part of Project Diversion.
Correct.
Yes. And Medicare 24 is not part of that.
No.
Okay, I got you. Thank you.
Thank you. Okay, so can we then go to page 16 of your supplementary statement?
Medicare 24
You
investigation.
have to wait for us.
Oh, I'm sorry.
And commissioners, we will be doing some file hopping. It's unavoidable because of the extent of the corroborating documentation that I need to take you to. So we will be dealing with file 11, which is the notes, both file 10, 10.1 and 10.2, and there'll be file 9. File 9, yes. Okay, so we are on page 16 at the foot of the page, Medicare 24 investigation, attempts to link General Masemola and further attempts to arrest General Khumalo. And then the subheading is the irregular section 28.1 authorization.
Thank you. Paragraph 35. As previously stated, the Medicare 24 matter was referred to by Advocate Johnson as the SAPS contract and visa contract. I do not know why. I only became aware on the 13th of May 2025 that the SAPS contract and visa contract was in fact the Medicare 24 matter. When I was asked to assist with checking the application for a 28.1 authorization prepared by another prosecutor, as stated earlier, Advocate Johnson had mentioned the SAPS contract and visa contract from 22 January 2025 after her meeting with Minister Mkhunu. Paragraph 36. In any event, at the meeting of the 24th of April.
It's 16
It's
April.
16 April.
So 24 must change to 16. You may continue.
Mr. Perumal had informed Advocate Johnson that Advocate Shabalala had already drafted a Section 28.1 authorization application for the Medicare 24 matter, which was with a DPP in charge of supervising Advocate Shabalala. Advocate Johnson was very agitated and told Mr. Perumal that he had no idea what he had just done, and that it should never have been done that way. She said that she did not even give Advocate Shabalala that matter, which I also later reflect in an email exchange of 13 to 16 May 2025. At the time, I did not understand Advocate Johnson's agitation because I had not been involved in the matter. However, when Advocate Johnson instructed me on the 13th of May 2025 to assist in finalizing the application for Section 28(1) authorization, I immediately appreciated the gravity of the situation. There was no Section 27 referral affidavit in existence at the time. Mr. Perumal had instructed Advocate Shabalala to prepare the application without a referral.
Okay, now we're going to have to go to a few documents in support of what you say there. The first is file 11, page 20. Do you have it?
Almost. I'm here.
Okay. So this is the meeting of the 16th of April 2025. We already dealt with it insofar as diversion is concerned.
Correct.
We now want to deal with it insofar as the Medicare 24 matter is concerned. And for that, can I ask you to go to page 28?
There's a line.
So this is your notes from that meeting.
Correct.
And what we see is there's a line in the middle, and then we see a name. Just bear with us for us just display, and then you may continue. So the middle, yeah, on page 28. So yes, you can go.
Okay, I must just explain that when I was noting these things down, it was a conversation that was happening between Mr. Perumal and Advocate Johnson in that meeting, and I was just noting what was being said. So there's a mention of Charity Matlo, which is a general that we all know. Then there's an indication that there's a forensic report, a procurement process prepared, and that Advocate Shabalala has done an authorization.
Okay, so here this is what you were saying is that this was when Mr. Perumal was communicating to Advocate Johnson that that Advocate Shabalala had already done an authorization in respect of this matter.
Correct.
Okay.
And submitted it to the DDPP.
Okay, then we have S27.
So Section 27 will be Matlo, and that the consultation with SIU will take place, and there's a specific person at SIU that will provide or give it to us.
Okay, now can we just deal with your note that says Section 27 equals Matlo? You said Section 27 will be Matlo. So this
Yes.
is now on the 16th of April 2025, and you're being told that General Matlo will be the Section 27 referral. She'll depose to the affidavit.
Correct.
Okay, in order for it to be referred to IDAC for
Yes.
investigation.
That
But
was-
you are having this discussion even before there's a referral.
This discussion is before a referral, and a 28(1) application has already been submitted.
This is the draft by Advocate Shabalala.
Correct.
Okay. Well, but when you say submitted, not to Advocate Johnson, it is submitted to the DDPP in order for the DDPP to submit it to Advocate Johnson.
Yes.
Okay. Now,
Sorry, and the section 28(1), did you see it? Is it in this meeting? Do you know that it does exist for sure at this point?
Section 28(1).
Yes.
the application.
On the
application.
16th of April, in this meeting, I had not seen it as yet. I get an email on the 13th of May, 2025. And then there's a whole chain of it, and then eventually I do get hold of it, yes.
Thank you.
Okay, so then if we can go to, that is the discussion regarding General Matlo will be there, and then on the next page, page 29.
So there's talk about General Matlo being the 27 referral, and that it's sent to Paul being Advocate Law, the Deputy Director.
Okay, and that is what you were referring to. But you say send to Paul, it's with him already, the draft,
Correct, it's with,
for consideration?
yes.
Do you get to know what preceded which? The section 28(1) application and the referral that we now, in that same meeting, you record that it has been sent to Paul Lowe.
Commissioner Beloy, at that point, I didn't know anything about what was happening. I do later find out that there isn't a 27. There isn't a referral affidavit. There's something else that's sent that is considered a referral, but it's not in fact a referral.
And in terms of dates, where does it sit, that document that you refer to? In terms of dates, where does it sit vis-a-vis this 28(1)A application?
Commissioner Balwe, can we get to that in the chronology?
Okay,
So
that's
then
all right.
you'll see what happens on the 13th of May. So you are then told in that meeting that the Section 27 referral has been sent to Paul.
Correct.
Okay. And Paul Lowe is the DDPP.
Correct.
Okay. Now, if we go back to your statement at paragraph 37, and there's a correction to be made there as well. You may proceed.
When I inquired about the Section 27 referral affidavit in finalizing the draft,
So the correction is that in finalizing the draft, Section 28(1) application must be deleted because your inquiry is in that meeting of 16 April.
Correct.
As you say.
yes.
So when I inquired about the Section 27 referral affidavit in the meeting,
I was told by Advocate Johnson that the referral was a preliminary audit report itself together with an email from General Matlo. I was never shown this email. I did not have the preliminary report either. I requested the report from Advocate Shabalala, and he sent it to me via WhatsApp. Apparently, he had received it via WhatsApp from Mr. Perumal. It must also, here there's a correction, either Mr. Perumal or Mr. Lt-Gen.
okay.
Who had received it from General Matlo. The file name of the report had a date of 30 January 2025, but I do not know when it was given to IDAC by General Matlo.
Okay, let's then go to the correspondence regarding that. So we, now on the 13th of May 2025, can we go to page 285 of file 10? We'll start at the bottom of file of that page of 285. It's an email from Advocate Johnson on the 13th of May 2025 to you, Mr. Perumal, and she CCs Mr. Sesoko, the PA, and she says SAPS Tembisa Hospital tender. You can read it.
Drew, you guys sent me a Section 28 application for this matter that Tilas drew up. I need you to look at it urgently and then submit. General McLeod contacted me and I want to authorize by Thursday. Check the designations, etc. and send a hard copy to Ino. Kindly remove Tilas, Paul, etc. from the designation. Add Santos as the advocate as well as he will oversee when I am unable to attend to things. Drew, I also need another advocate to help you. I was thinking of Joy. If you agree, then add her and I will speak to her. She will get it to me, where I am tomorrow, meaning the hard copy.
And then you respond at the top of that page at 12:35.
Morning, Advocate Johnson. I will obtain the same from Tilas. I have not had sight of the documents Tilas submitted. Once I have, I will attend to the necessary and submit. I have not worked or interacted much with Joy. A second prosecutor would be much appreciated due to the volume. Thank you.
Okay, then if we can go to file 10-2, page 602. Just let me know when you're there.
I'm there.
This is the communication between you and Advocate Shabalala on the 13th of May, 2025. And we're looking at the voice call at 12:35.
Correct.
That's where you now contact him to get information regarding the 28.
Correct.
Okay, and he's not answering your call. He calls you back, and then you send a message to him.
Yeah, he called back to say that he's in court. So I sent him a message. Hey Shab, hi Shabs. What documents did you base your 28 application on? Or rather, where did you get the information on suspects or information from? He then calls back. He says to me, that he had gotten it from either Sunil or Mr. Beluchin or Mr. Perumal, and he then forwards me the SAPS preliminary audit report, 94 TP, 30 Jan 2025.
Okay, and then in between you calling him and him returning your call and forwarding the report, you try to get the report from somebody else. And that we find on 263 of file 10-1. So at the bottom of that page, 263. Can you just explain?
Yeah, because I couldn't get the 28 documents, draft documents that he had submitted. I contacted the project manager that is allocated to Advocate Low's team, Ms. Modiba. And I asked her for the authorization, the new authorization sent by Tilas, and then she sent it to me.
Okay, and the subject there is Tembisa, new authorization. Good day for your attention. If we go to 264, you'll see the attachments. It's an application in terms of section 28.1, a section 28 authorization, Vusimusi Matlala, and a section 28 designation, Vusimusi Matlala.
Correct.
Okay, and you, at the top of that page, you send it to Advocate Johnson.
Correct.
At 2:05.
Good afternoon, Advocate Johnson. Attached is the application drafted by Advocate Shabalala. Kind regards.
Then if we go to page 281, Because there was quite a bit of activity on the 13th of May. At the bottom of 281, you hadn't yet sent the application to Advocate Johnson. You sent it at around 2 o'clock.
Correct.
But you had said to her that you'll try and get the information from Tillis. She responds to your 12:35 email, and she says to you at 1:44, if you can just read that.
Subject, R.E. SAPS Tembisa Hospital tender. Drew, ask Chief to give it to you. I don't want Tillis wondering why we are now taking the matter. I never assigned him in the first place.
And this is in reference to the fact that at the meeting of the 16th of April, she was agitated that Mr. Perumal had gone ahead with the 28-1 and gone to Advocate Lowe without her involvement.
Correct.
Okay. And she says, I never assigned him in the first place.
Correct.
Okay. Then she tells you to go to the chief, but you had already approached the chief before she told you to go to chief. That we'll find on 604, which is in part 2 of 10.
Correct. There's a voice call between Mr. Perumal and myself. And then at 13:08, hi Dee, what docs did you give to Shabs to draft the 28 for the hospital? Need to confirm the submissions. He is currently busy and isn't responding. Please send to me. I know you are in consultation, so when you are able to, thanks. He replies, hi, don't know what he would have used to compile it. Okay, we'll wait for him to reply, meaning I'll wait for Advocate Shabalala to reply.
So Mr. Perumal is saying he doesn't know what Advocate Shabalala had used to compile the 28-1 application for authorization. Yet he was the one that asked Advocate Shabalala to do the authorization.
Correct, and when I had this conversation with Advocate Shabalala, he said he had all the proof to show that who sent it and whatever, but Mr. Perumal is denying it.
Okay, if we then go to page 281 of 10.1, this is now at 1350.
Advocate Johnson, I have asked Dylan for the documents that Tillis used as a basis for the application. He indicated he does not know what Tillis used as a basis for identifying suspects as listed, as well as the information on the committees contained in the 28. I obtained the 28 from Obusha as Tillis was unable to take my call. I need that information to confirm the Vermon's allegations to be authorized.
And then on page 280, Advocate Johnson responds to your email.
Colleagues, this is what happens when we involve people without the ID. I heard from this team that he had drawn up an application, and hence my remarks about why and on whose instruction. Please send me what he drafted and then ask him via email to send you the basis for his application.
And so Advocate Johnson is now saying this is now what happens when you guys don't involve the ID. Again, with reference to what happened in the meeting of 16 April, her
Correct.
not being involved in that process. We know then that you say to her that you did get the document, the report, and you ask her for the code. So if you can go to page 452, you can just explain to us 452, which is part 2 of 10. This is still on the 13th at 14:25 from you to Dylan, ceasing Advocate Johnson, Mr. Sesoko, and the PA, documents from Drew. Yes.
Afternoon, Dylan. I received General Matlow's report via WhatsApp from Tillis. It is encrypted and he can't remember the password. He indicated if memory serves, he got the documents from Sunil.
And that's Mr. Beluchan.
Correct. Please assist with the password so that I can urgently peruse the report and submit timeously to the ID. Your assistance is appreciated. Thank you.
Then if we go to 454, we'll see the encrypted document there, file details, SAPS preliminary audit report 94 TP 30 Jan 2025, encrypted 2212 final.pdf.
Correct.
Okay, and then on page 455, Advocate Johnson responds to your email.
The password is?
Yes, and then she says,
I also want a copy of this report with the application.
okay, so you then now have the draft applications and you have the report.
Yes.
You still don't have a Section 27 affidavit.
No.
What does the report reveal? And what is the report? So it says preliminary report 30 January 2025. That's what it's saved as.
It is, so from the mandate, which is the first page, it indicates that it's an,
Can we go to it? Is it not much easier to go to it on file 10, page 301? Is that not the one?
Page?
File 10, page 301. So if you look at the date on
Correct.
306,
Yes, that's
it
the one.
should be the one.
yes, correct. So it indicates that risk management was a request to conduct an audit by internal audit and risk management was submitted by the Minister of Police through the National Commissioner on the 9th of January 2025. The internal audit and risk management performed a joint audit in respect of the bid. It does relate to quite a few irregularities and
Yes.
persons of interest. I don't feel comfortable.
No, that's fine. That's why I
going
didn't want to.
into the details of the report.
No, that's fine. I don't want you to deal with the details. That's why I just wanted to ask you from memory what you recalled about it. But if you go to page 306, there are signatures there, and General Matlo is one of the signatories.
Correct.
Okay. So you have the report now and you've got the applications. You finalized the application.
I didn't amend anything. I read through the report, I read through the application that was drafted by Advocate Chabalala. It's fairly comprehensive. I followed the instructions of the ID and changed the names of the persons to be designated on the matter. I also sent her a WhatsApp to confirm that the designated people need to be the same as Project Diversion. She confirmed and she indicated I must add Mr. Mbalo and Mr. Belocha.
Okay. Now, did you email the application to her? Or?
If we take note of the first email she sends to me, she says that a hard copy must be delivered to Ino, and Ino would get it to her wherever she is. So I did deliver the hard copy to Ino, and I think on the 16th of May, Ino scans the signed copy of the 28 one and sends it back to the team.
Is that
Okay.
the one on 287?
Sorry?
287, is
Yes,
that the one?
that's the one, yeah. But I just wanted to confirm you didn't actually email the application to her. It was delivered to Ino.
Correct, it was hand-delivered to Ino.
And Ino then sends that on page 287. And if we go to the document, so 288 shows the attachment. And then on page 289. Now, can I just ask you, why was this a 28-1 and not a 28-13?
Like I said, I didn't change anything. I submitted it as Advocate Chabalala had drafted it. I only amended the designation. So I only made changes to page 6 of 7.
page 6 of 7. Okay. Before we get to page 6 of 7, in the correspondence there was a reference to, I don't know, where did he get the name of the suspects? Was that in the report or already in the application?
Yes, correct. The report did link the names as mentioned here.
So the suspects mentioned in the document was reflected in the report?
Correct.
Now, importantly,
Sorry, about this, maybe it's important for accuracy, even if you don't read out the names, to mention the context in which they appear. So, for example, you have people listed under the bid evaluation committee, and their names appear there. Some of them are amongst the ones charged, and I think if the report doesn't make any specific allegations of criminality against them or of irregularity against specific individuals, I think it's in fairness to those individuals that you should say in what context they appear in the report.
okay, can I deal with it when we get to the end of the report? Because what I want to deal with first is the designated individuals. And I want to highlight one name in particular, and that is on page 294 at paragraph 30. It is submitted that the following persons be designated to conduct the investigation. And at number 11, you see Major General Matlo.
Correct.
Now, Major General Matlo in the meeting of 16 April you are told she is the Section 27 referral.
Correct.
And General Matlo is not part of IDAC.
No.
She's part of SAPS.
Correct. Risk management.
Why was General Matlo included as being part of the investigation?
With the investigators at one of the meetings, because I wanted to know how do we...
We can't hear you.
Sorry. How do we designate the complainant in an investigation? Because obviously she's going to be the A1 and now she's part and parcel of the investigation as well. And the other issue that I had was, where's the documents for duty reassignment? If we are designating a member of another unit, you still have to have correspondence between their supervisors. So it would have been either Mr. Sissoko or Advocate Johnson, and I think it's NASCOM that risk management reports directly to. So there would have been an agreement and formal communication of duty reassignment, even if it was just for that aspect. Because we've had it before. In fact, we still have it at the moment. I'm dealing with one of those matters where we have communication of duty reassignment. So one of my questions was, why is General Matlo the complainant part of the investigation, and where's the documentation of duty reassignment? And I was told that the ID authorized it, but it wasn't so politely put to me.
Now, at this stage,
So it's an irregularity, you're saying, that you would have, well, there's the obvious point about you would have a complainant being part of the investigating team, but more importantly, you're speaking to an irregularity about the duty assignment authorizations.
Correct.
There wasn't a record of that.
Correct. If I can give you just a small example. So there's an investigation that I'm working on with another DD at the moment. And even though the A1 is in fact the investigating officer, because he had started the investigation based on the Zondo Commission recommendations. So he is the A1, he's the complainant, so to speak. But he is from DPCI, and in the docket itself, we've got in the B clip, his duty reassignment documents.
and you say on this one, you haven't seen that duty reassignment, you haven't seen anything other than the 28?
Correct. I've only seen the 28 one, and I've seen the preliminary reports, the encrypted reports.
Okay, then we can go to page 292. And I'll just ask Commissioner Baloyi for guidance here on this aspect insofar as the suspects are concerned, the issue you raised.
So what I wanted to be careful about is that we don't create the impression that the report has fingered specific people, linking them to specific misconduct. So if you look at, let me go to that page. If you go to a page that lists committees, 311, thank you. So if you go to that page in the report at 311, it lists different committees and tells you who is in the committee, who are those people in the committees. And insofar as it doesn't allege, there's no misconduct, irregularity, criminal conduct alleged against a person, but the only link we can make from the report is that they sat in a committee. I would rather you point that out.
Yes, I wasn't going to deal with the suspects. It wasn't part of the 28-1.
Okay.
My focus was on the designation, the investigators,
Okay.
what was being investigated, why was the complainant included as being part of the investigation, and whether there was any authorization for that, what did we need in order for that to be, that was the...
That's your focus.
Yes, that's why I didn't deal with the report either.
Okay.
Just
I
the
guess-
issue of the report was just that it was sent to you when you were told that the report is the 27, it was part of the 27 referral.
Correct.
Okay. No, I'm happy with that. I was just concerned when she said I'm uncomfortable to list people's names. Okay.
But just to, the report says the bid was not properly evaluated. So to the extent that there are issues with the bid evaluation committee, all the report says is that the bid was not properly evaluated. And it doesn't allege criminality.
Yes, that is why I wanted to establish the extent of this witness's involvement with that. And as I understood her to say, she didn't change anything on the authorizations. She wasn't really involved in in assessing the merits of the application. You were just finalizing it for submission.
Correct.
Okay, because the names were there. You didn't check whether the names should be there or should not be there. That's why you asked, where did you get the names?
Correct.
Okay. Now, at this stage, you still haven't seen a 27, a Section 27 affidavit.
No,
Okay.
not at all.
If we can go to page 544, which is file 3. Do you have it? It's the transcript of Advocate Johnson's evidence before the ad hoc committee.
I'm here.
And at 544, it starts at the top by Advocate Aronsa. Do you want to comment on the subheading IDAC investigations into Mr. Vusi Musikat Matlala? Advocate Johnson says, IDAC received a Section 27 referral from SAPS Risk Audit Division, and this is not the first time we would have received referrals or work with the Risk Audit Division. There are many matters currently in IDAC where one is looking at corruption, the PFMA contraventions, and fraud related to the supply chain. And then if you skip the next two paragraphs, it's Advocate Johnson again. The first and only time that we are looking into allegations against Mr. Matlala relates to the 360 million rand tender that was awarded and then subsequently cancelled sometime this year. So there have not been criminal investigations into him as a service provider. We have criminal investigations against SAPS members and other service providers where the supply chain management processes are circumvented and corruption or fraud or PFMA contraventions took place. In February of this year, this would have been 2025 because she gave evidence in 2025, is the first time that we got a referral that relates to Mr. Matlala as a potential suspect, either in fraud, corruption, or together with other SAPS officials' contraventions of the PFMA. We received the referral on the 16th of February 2025, and then through the media, as we paid attention, we found out that Mr. Matlala had been arrested and his phones were seized. Now, do you know of a 16 February 2025 referral?
No.
And then at page 546, Advocate Aronsa asks, now this referral on the 16th of February this year, where did this referral come from within SAPS? Advocate Johnson, the head of their risk audit referred the matter to IDAC in terms of Section 27 referral, deposed to an affidavit, attached supporting documents, and the matter came over to IDAC. And then he says, when would you first become involved in this referral, if at all? And Advocate Johnson then says, when matters are referred, they almost invariably come through one of the chief criminal investigators, more so through the head of investigations and operations, Mr. Matthews Sesoko. They would receive the matters and go through the matter at a cursory perusal to see whether or not it is a matter that IDAC can take. They then compile an application, which we call a Section 28 application for the ID to consider whether or not to authorize an investigation. That is the first time I become involved in applying my mind to the matter. Here the matter was then authorized. When it is authorized, investigators and prosecutors are designated to conduct the investigation of these matters, as it is a prosecution-led methodology. But the investigators and the prosecuting team go through determining what task activities, line of investigation should be followed. It is not for the ID. And he says, so there would first, Advocate Aronsa, so there would first be what sounds like a preliminary investigation that you would authorize. And she then says there are two types of investigations. Usually we get the Section 27 referrals. Now, Advocate Johnson seems to say here that on the 16th, because it's in directly in response to Advocate Aronsa asking her about the 16 February 2025 referral at 546. She says, the head of their risk audit referred the matter to IDAC in terms of Section 27 referral, deposed to an affidavit, attached supporting documents, and the matter came over to IDAC. And this is in response to a direct question about now this referral on the 16th of February this year. Where did this referral come from within SAPS? Was Advocate Johnson, have you seen a 16 February 2025 referral?
No, and even on the 13th of May, there was no 27 referral. There was just the report that was bouncing between IDAC employees via WhatsApp. And if we take note of the email of Advocate Johnson on the 13th of May, it says, I was contacted by General Matlo, and I want to authorize.
You can go to page 3519 of file 9, where there is an affidavit by General Matlo. It's file 9. 3519.
I'm there.
This is an affidavit at 3519 by General Matlo, and if we go to page 3521, on the 6th of June, it's signed, commissioned on the 6th of June 2025 at Pretoria. Do you see that?
I do.
And this was referred to as the Section 27 referral during Advocate Johnson's evidence.
How can it be a 27 referral if the authorization is done on the 16th or signed on the 16th of May? The Act says 27 referral and then authorization. So if they're saying the 6th of June is the referral, then they were working backwards.
And if you look at the affidavit, the contents of the affidavit, at paragraph 3,
Okay, I've got it in front of me, yes. Paragraph 3.
I hereby submit this affidavit to the investigating Directorate against corruption in support of initiating a criminal investigation into the alleged unlawful awarding of a tender to Medicare 24 Tshwane District Pty Limited to provide medical health care services to the SAPS for a period of 3 years. The monetary value of the tender was approximately 360 million rand. So this is the affidavit where she says she wants the investigation to be initiated.
Correct. If we just go a little bit further down, it says something about a final report will be provided. A comprehensive internal audit report is currently being complied.
What paragraph?
Paragraph 5, which will shed light, further light on the alleged criminal misconduct. This is where the fight between myself and the investigators started. Because way before this, in May already, I'm asking how can we be investigating something where a report has been requested, an internal report has been requested by the NASCOM, and the final report is not submitted. So how are we authorizing an investigation where we don't have a final report? It didn't make sense to me, and that was the start of a lot of problems.
And when was the first time you saw this affidavit?
When it was flighted at the commission.
When it was during Advocate Johnson's evidence?
Testimony, correct?
Okay.
Is it not odd that according to Advocate Johnson, the referral was made in February, but the Section 28s were only being done on the 15th of May? So that's 3 months later. Now, if you follow the sequence according to her evidence, it first goes to Mr. Sissoko, and then there's an application to her, and then she authorizes in terms of Section 28. So how does one explain that 3-year gap from the date when she says 3 months, 3 months gap from when she says the referral was made to the 15th of May when you are discussing with Advocate Chabalala the Section 28?
Commissioner Khumalo, I'm going to say it again, although I got into trouble for saying it last week. When there's cover-ups happening, timelines and rational decisions cannot be explained. So because from the timeline here, how do you explain anything? It's basically them trying to cover up, but very poorly so. It's just my observation, and from dealing with these things for so long.
And then there's another affidavit by General Matlo that I'd like to refer you to at page 3534.
File 9.
Before that, even if it's just for the record, so at least from what we have seen in the ad hoc committee transcript and this affidavit now, and the WhatsApp exchanges and email exchanges, we can say that Advocate Johnson did not tell the truth in Parliament to the ad hoc committee when she said you received the Section 27 referral on the 16th of February 2025. That was an outright lie, looking at these documents.
Correct.
Thank you.
Sorry, which page, Advocate Siko?
It was 3519, I think I said.
3519.
3534, sorry.
3534. Yes.
This is a A2 statement, and I'm not clear on when this was done, because if you look at 3536, where do you see the 26?
284-page affidavit. So the last
Yeah,
page
at the
is
last page.
3817.
Because what happens is she verbatim quotes from a report. So we'll get to that. but in this affidavit on page 3534 at paragraph 3, General Matlo says on 9 January 2025, Internal Audit, Risk and Integrity Management received a request from Minister of Police to investigate the alleged procurement irregularities on appointment of the service provider to render health risk management services for SAPS at the Division Supply Chain Management. And then it says Appendix 1, copy of email request for investigation from the Chief of Staff and mandate. I led the investigation team to conduct an investigation into these allegations. So that is in 9 January 2025. Were you aware when General Matlo's name was mentioned or regarding the Medicare 24 that the investigation that she undertook was at the request of the Minister in January 2025?
No, my understanding was that it was NASCOM that asked for the investigation.
Your understanding it was the National Commissioner?
Correct.
That had asked for the investigation, not the Minister?
No, not the Minister.
Okay.
I understood it from the meeting that we'll discuss now. I understood it to be that the Minister spoke to the National Commissioner, Masumula, and Masumula then requested the report.
Yeah, that's what you were told.
Mm-hmm.
Okay.
And that's what the interim report says.
Yes. So insofar as, but never in the discussions about Medicare 24, either with General Matlo or Advocate Johnson, was it mentioned that the preliminary report or the investigation comes from a request of the Minister?
No.
Okay. Now, can we then go to what transpires at the meeting of the, I think it's the 27th of May, before we get to the meeting of the 2nd of June. So that would be on page, it starts on page 49. And then we'll go back to your report.
Okay.
Do you have it?
Correct.
Okay, so, file 11, page 49. And there were discussions about project diversion, ID authorized section 204, but I'm interested in your recordal on page 51, which is a meeting where Mr. Pariachi, Perumal, Tlale, Patism Lambo.
Correct.
Charles is? Els, and the ID and you were present.
Correct. This took place at the Fire and Ice.
Okay.
Is it the same meeting that starts at page 49?
Correct. It was a two-part meeting. My apologies. So this meeting, the ID1 said it was discussing the
Should we take a short break?
I was going to suggest
Indicate when we should start. Let's adjourn.
Thank you. Okay, so we were on the meeting that starts on page 49 on the 27th of May. And I was referring you to page 51 where there's a reference to Tembisa. You can just tell us what you were recording here.
Correct. The ID had wanted she still continued to call Medicare 24 Tembisa. So she wanted feedback with regards to what was happening. And then she indicated what was going to happen about the cyber search and asking DPCI for the phones, more specifically Colonel Khumalo. I have to explain this because it's not a detailed note. I think I stopped last week when I was explaining the phone issue. The investigating team led by Mr. Perumal and Mr. Lt-Gen wanted to actually physically remove the phones from the initial seizures. They wanted to go and collect the actual phones. And I said that legally it cannot be done that way because you are now breaking the chain of custody in that docket. You would then need to serve a warrant on Mr. Matlala. It's section 29, capital A, 1A, cyber search warrant of the Cyber Crimes Act, and also serve it on the current holders of the phone. You would have to go with a digital expert, a service provider, and mirror image the phones and work off the mirror imaging. You cannot take the original. You are breaking chain of custody in different matters. So that was an argument that transpired. And then somehow rationality prevailed and they proceeded in the manner that I explained it had to be done. They then further on page 52, Advocate Johnson and Mr. Perumal indicated that they had to do a J51, and then I was to do an extension on the designation to include the forensic investigation that was to be outsourced. And that they wanted to do the search warrant at the house, being the J51, and the cyber on the same day. And they were supposed to provide feedback to Advocate Johnson on all of this on the 10th, between the 10th and 15th of June.
Okay.
Did anybody ever ask Advocate Johnson why she referred to this as the Tembisa contract?
Chair, I think Advocate Johnson was as confused as I was in the beginning, or maybe she just was using it as Tembisa, because on the 16th of May, I even sent articles about the Tembisa, saying that other units are involved. There's already been search and seizure. My apologies. And that she then sends a message to me. It's not the same matter. So that's why I'm saying I'm not sure if she didn't know or if she knew, but she did refer to it as the Tembisa.
Thank you.
On page 53,
Yes. It's reference to Matlo's report. What
correct,
report
that
was
is
that?
the preliminary report. And the question Advocate Johnson asked was, has Minister received reports? And what usually happens after reports like this, requests are completed. Forensic investigation, who, how, when, will it be finalized? So these questions, when Advocate Johnson's questions relating to Matlo's reports, and that Mr. Perumal and Mr. Lt-Gen were to get the information from her. And then Advocate Johnson referred me to the National Health Act, that I must read up on it when dealing with this matter. I was then instructed that a memo must be done for cyber services and the service provider to be extended onto the memo.
Chair, I know that Ms. Ramsamy wants to continue because she wants to finish her evidence, but I think we should adjourn. Yeah.
I think.
And unfortunately, we'll have to finish it tomorrow. Or I'll have to discuss logistics because I know there are other witnesses. If we maybe can just take a short adjournment so I can get hold of Advocate Chaskelson just to find out what the arrangement is for tomorrow. Because I'm not sure if we can even continue with her tomorrow if there are other witnesses scheduled for tomorrow already.
We did hear from your counsel, Ms. Ramsamy, Mr. Ramatsekisa, that you would like to finish today, but observing you from where we are, you are struggling.
I am, but I'm strong enough to push through for as long as possible. I think we can push until at least 4.
I don't think we're going to achieve much till 4. Yeah, I think, Chair, we should just adjourn. We're not going to achieve much in 30 minutes. Yeah.
Let's adjourn, then you'll call us in when you're in a position.
Thank you, Chair. Thank you, Chair.
Yes.
Chair, we've arranged for Ms. Ramsamy's evidence to then be stood down until Friday, the 14th of August at 9:30.
Contrary to your wishes, that's what must happen, unfortunately. We will resume with a hearing of your testimony this Friday.
Thank you, Chair.
We resume at
Chair.
9:30 tomorrow morning.
Yes, Chair.
Let's adjourn.
Thank you.